consent of the other side, I beg to mention item number 5 on the grounds of bereavement of the family of Mr. S.P. Sharma. Yes, Lordship, perhaps it is come for admission, Lordship. There is no office note, Lordship. I have already said, Lordship. See, Madam, I have checked the office note. Last instruction was for them to file an affidavit. Develop file. Reminder. Don't take action. We then allow your petition. Lordship, otherwise, Lordship, we have prepared the affidavit, Lordship. And we will file with proof. Yes, Mr. Ho. Anything listing of a repetition method. Listing of a repetition tomorrow method. In fact, it is the admission matter. Admission matter method. And it is tomorrow method because they have already there in stay order method. They have things subsequently. PWD program. That will become date.
Repetition was earlier directed to be listed tomorrow, madam. It has not come up in the daily list. And madam, there is this matter was heard by your lordship regarding option of that Kachar paper name.
Oh, that's fine. Part of
No, it is not part of my residuary bench for matter. So, madam, it was directed to be listed tomorrow, madam. But somehow it has not been listed tomorrow.
without people they raise the
No, madam, mention is
can we allow mention because directed to it should be. Okay, please, your lordship, praying for listing of an IA, your lordship, your lordship. But since the lordship is ordered in the repetition that within 10 days, they have to supply, the IOCL is to supply ERB slips. Yet communicated lordship on 4th and on 5th, what they have done, they have issued a letter saying that lordship, we are going to deduct the amount without providing ERB slips. See, it's money only. Lordship, but money already lordship, 2 installments. They are not complying with your order, your lordship. Then see, for your lordship now. I think money will have it mixed. Money to what is there? In there being here already the agency is already has suffered a lot, your lordship. Lordship knows about it, lordship has handled the cases.
What do you say? We go when we pass an interim order on 3 principles: prima facie case, balance of convenience, and irreparable loss. Can money be the concern for irreparable loss? No. That's well settled by the Supreme Court. So deduction of money, how does it matter? And deduction is how much? You will get back. If anything, no, anyways, your agency is otherwise closed also.
Because the software is still functioning, your lordship. The consumers has been allotted other agencies, your lordship, but still they are functioning, your lordship. It's not. Your lordship, that is the lordship. Already my money has, we are losing money, lordship. And our father, if my
Money, no problem with that. We'll get back the money if it is an illegal deduction. And if there is a violation of the court's order, obviously contempt lies.
Already lordship, 4.5 lakhs has been deducted, lordship. And they are not complying lordship's order, your lordship. Instead, they have issued a letter on 5th, lordship, saying that we deduct order. Without providing
Instead of filing an IA, file a contempt. We'll take it up.
No, lordship, lordship in contempt, lordship, we'll do that, lordship, by the next week, lordship. But lordship, kindly tomorrow, your lordship.
If they are not listening to my order pass, then why will they listen to an IA pass? Any order passed in the IA? You have to give me the jurisdiction for contempt.
Lordship, perhaps lordship, contempt will also lie, your lordship, but a direction, a proper direction from lordship will.
I'm saying that this court did not pass a proper direction.
No, further direction, lordship, not proper, sorry, further direction, lordship. I'm really sorry, lordship. further direction will be necessary, Lordship.
Okay, Monday.
Lordship, then Tuesday, your Lordship. Huh? Tuesday, Lordship.
Tuesday,
Yes, Lordship.
right?
Lordship, Monday, some people.
Because that means you don't have an urgency.
Lordship, the agency is, my petitioner has the urgency, your Lordship.
They will have it on Wednesday. Tuesday is for other matter. See, there are a lot of labor court matters.
Yes, Lordship. That is-
Needs to be finished up as soon as possible. And therefore, it's very sad that although the act categorically mentions to dispose of these matters within 1 year or so, and these matters are pending before this court for the last 10 years. So therefore, I didn't give any, yeah.
We'll try to further what we can to them not to differ.
Well, you say about it, because there is no direction for me to not to be done.
There is no direction.
So
The
that
direction is so subject to. Subject to.
I only say, if any deduction is made, it does
That
not
will be
subject to
subject
the outcome. So if there is any deduction being made and you paid for them, and I have rejected,
Yes, Lordship.
now you want by filing an I.
No, I'm not.
That day
asking for
your senior made an argument on constructive litigator. Why?
Lordship, I'm not asking for a direction not to deduct. I'm asking for a direction to provide the ERB slips to comply with Lordship's order.
If they don't provide, in spite of that, then the content. So therefore, it is not a question of deduction.
But that is also.
So don't come up with that prayer with the I.
No, I will
Your
not
prayer has to be on the question of
providing ERB slips.
Yes,
Yes, Lordship. That I've kept in mind, your Lord.
Wednesday.
But when it's much of this. All right. Which is laid down. When the election.
Before that, I would like to place once more the certain facts which are very crucial here. The I'll take your lordship to that. For the time being, lordship may keep it aside for the time being. For the time being, lordship may keep that judgment aside because I'll place certain facts which will definitely have to be taken into account while considering that. Because this has laid down the dividing line when the court can and when an LOI should be construed or can partake the character of LOA and they are bound by it. And my responsible submission is here is a case where the authorities are bound by their own action and they cannot retreat at that stage. And I refer to a certain clause. I'll place it again.
Or you may very well submit, taking into account their.
Lordship, may kindly take the mic little nearer so that
Or you may,
Yes.
taking into account the materials, or more particularly the clauses of the tender,
yes.
they have been using the words LOA and LOI interchanging.
Well, let LOI, as they say, LOI is merely an intention in ordinary course. That is the interpretation of the apex courts also. Very many judgments, including that 2006 decision. There. Now here, but then it always depends upon the circumstances, attending circumstances, and the terms of the contract documents. Whether at that stage when they issued the LOI, though they named it as LOI, whether that is only an expression of their interest or it goes further. To that extent. Now here, what you will see as I placed it earlier. When the LOI is issued, firstly, LOI has been issued only after verifying all documents, those who are required to be filed, along with my tender. And then the further documents they asked me to place before it for their satisfaction. And having considered everything, the tender evaluation committee, of which the MD, Managing Director of the APDCL himself is the chair, has taken ultimately a decision that I come L1, I am a responsive bidder, and I am the L1 bidder. But they find me that he is below the mark because it is below the value of the tender. That bid. Therefore, they categorize me as abnormally low bid. And that circumstance, what to do? They may impose further conditions to ensure that by being awarding the contract to me, I may not fail subsequently to execute the work. They need secure. That has been taken care of by clause 28 of the documents. And therefore, they issued the LOI to me and asked me that within 7 days, you inform us and accept it. Else, you will be penalized. Penalized in the form that you will forfeit your security deposits. In that context, you will have to now see whether this LOI can be constituted as an LOA. Yeah, Lordship will kindly see. If I kindly take a page 130. And this is the Lordship, first one. Yes. Okay. The rate creation. Yes. Yeah. I'll have white for the yes. The term intent their subject is they have referred to MIT. They have then say we will intending order for application of laws that was protect risks against the above referred MIT as decayed rules. Now, we have to
But what do you say, Mr. Mohanto, about the opening words of this particular thing, wherein says intending?
right. Whether that intention has to be construed only an intention or it goes further. That's why I'm drawing a lot of attention. Opening line, yes. But whether that is final or it indicates something else. No. Therefore, I'm time and again bringing a lossless attention to this particular document. Now, value of the work we have time to area of operation we have given. Team of work they have take for this notes. Completion period they have mentioned 180 days. Then detailed work parameters, terms and conditions as declared in the clear document of 19 of the future amount of that is 11/5/2025. And six, submission of additional performance guarantee for ALB. Thank you for this. Since your quoted price is 1929, low to low estimate of additional performance guarantee as per ALB law stated in this document. This document is to be submitted by you along with contract performance guarantee of 10% of contract value, that is rupees 99 lakhs. Only, which shall be valid for the period too extensive with the contract performance guarantee. Remove the additional performance guarantee 5% of the contract value that is 9,95,000. Which is equal to 9,499, which is equal to 9,96,553. On, so you have to deposit this. And then next page, Lordship will see acceptance first. Kindly treat this as the letter of intent and convey your acceptance of the same within 7 days from the date of LOI. So it has two facets. Firstly, right, informing you that we are accepting your bid. However, you will have
No,
to.
we are not accepting. The intent.
Intention, right, sorry.
There's a
We are
difference
in-
between that.
intention, we have the intention to accept your bid. First, we have the intention to accept your bid. However, you will have to comply with these conditions.
You have to
Additional,
comply now. Do you accept these conditions?
that's,
There's a difference.
otherwise, unless you accept these conditions, no. If you accept it, give it within 7 days. Right?
No. That is not. Kindly take this letter of intent and convey your acceptance of the
Acceptance.
same within 7 days.
7
You are
days.
not required to submit the additional performance guarantee within 7 days, but you have to accept the intention of the year,
Yes,
which means it appears to be a bid which is being, it's a more like a open bid which is being given. And thereupon you have submitted your offer and they have taken into account that your bid is lower, says that this is a counter offer being given to you that you have to pay this additional amount of additional security deposit. And do you accept to that? This is what the intention is.
Lord, why I'm saying, they have used that 7 days period as per their own clause 11. Here, Lordship may see again the clause 11 of the NIT. Where only the LOI finds place. Page 391. Submission of bid 11 with the ED. Each month is submitted electronically showing proposal. Technical commercial data by EMD should be submitted online, each of earnest money, 55. That's and it will be outright. The EMD will be successful bidder will be released on submission of 10% performance security deposit.
Now, Mr. Mohanto, did you submit the 10% of the performance guarantee on 5/2/2026? No.
Yes.
When did you submit? You couldn't have submitted.
Did that 7 days.
I'm not on that. Did you submit the performance guarantee or is on that date? Prior to that.
Performance guarantee when EMD is required to submit.
So therefore, the difference is this. When you are issuance of finally come now to 7, the successful bidder shall have to make an agreement with the so and shall have to deposit the security money in the form of a bank guarantee issued by so for an amount of 10% of the in favor of valid for a period of 60 days from the date of year. The security deposit is liable to be forfeited in case of non-execution of the agreement of the year. Now, if we read 7 with 10, 11, you'll see that this, once you deposit the performance security, then in that case, to the undersigned as per clause of the bid document, the EMD of the same will be forfeited on non-acceptance of the LOI. So the letter of intent being issued to you, and if you don't accept to that we are not going to go to submit the performance security also, then the EMD would be forfeited. That's okay. Now, here is a case where the letter of intent has been issued. As on that date, you have not submitted your performance. So this is a counter offer being given to you at that point of time that look here, we have looked into all your papers out there. And after looking into all these papers at that point of time, we find that there is an abnormally low bid And when there is an abnormally low bid, so therefore you are to pay an additional 5% of the security deposit as a
Besides the
performance security.
performance guarantee.
Additional.
Additional.
Additional. Now the words used in the last line out there, if you do you convey your acceptance of the letter of intent, meaning thereby you are to say that look here, I am accepting it, I am okay with this 5%. Thereupon the question arises out there. Now this becomes his counter proposal becomes your the letter which you are going to say that I'm accepting it, that will be your counter offer to that, thereby accepting it. And once it is there, then there is a formation of an agreement,
Exactly, my lord.
which has
And
not
they-
happened.
I have accepted. I've said immediately I responded.
So therefore, you see, once that has been accepted by you, then there is a requirement of a letter of acceptance. Where is the letter of acceptance?
So given.
There's no letter of acceptance issued.
Yes. On 6th,
Where?
129. 129. Acceptance of LOI at page 129. And
This is
immediately,
your acceptance.
yes.
So
Whichever
this is
you are
your, where
above.
is their acceptance, issuance of a letter of acceptance?
No, my lord, it was written to the chief general manager by,
This is by you.
Yes.
You accepted it. You accepted within this letter, this counter offer which is being made, you have accepted this
yes,
on 6/2.
yes. There should be 5-2. I accepted on 6th. I
6/2.
gave them the letter.
Now, once you have accepted, isn't there a requirement of an agreement or a letter of acceptance?
Then I have submitted along immediately performance guarantee, contract guarantee, all those is required, additional performance guarantee, everything I have given. They do not deny it. It's there.
So therefore, your case is, you having accepted it, is a case of specific performance at best.
No, my lord,
Instead of going for a specific performance, what they are doing out here is, they have cancelled it.
yes. They ought to have gone further to act as per the terms of their contract.
So therefore, if it is a case of specific performance, means there is no performance at all.
Now, performance here, my lord, my response submission is the moment I accepted their offer, my lord, this additional guarantee, performance guarantee, normally performance guarantee. But because it is abnormally low bid, they wanted me additional performance guarantee and additional contract guarantee. So I have given 70 point something to the tune of 9 crores. I have given that additional guarantee. They have confirmed it from the bank. Page 133. Page 133, Lordship will find APDCL has written to the bank whether I have that fund or not, bank guarantee has been given or not. Bank has thereafter confirmed it.
What happened after 6/2?
6-2, thereafter 6-2, I submitted, kindly see at page 133. 9-2, they have written to the general manager,
8.
page 133. Canara Bank. Bank guarantee is confirmed. Last line, Lordship will say, now we are sending the confirmatory copy of the same, and we are requested to check the correctness of the same with the original and also confirm us having received the same. What they did thereafter,
Yes.
then kindly see 141.
On 10/2, see 141, 10/2.
10-2. Yes. On 10-2,
So they have increased it.
my lord,
They have increased it.
They have, they have, they have confirmed it. This is the letter to the Chief General Manager, Assam Power Distribution, so and so. We confirm your email dated 10/2/2026. Subject Lordship will see, Malad, the APDCL returned to Canara Bank by mail dated 10/2/26, and that day itself, they have returned back. We confirm, having issued DG reference so and so, 99 crores, 93 lakhs so and so, DG so and so, for rupees 49 lakhs 96,000 in favor of the Chief General Manager FNO on behalf of Messrs. Wind Power Intracom LLP, for which are mentioned below. So these are the amounts given, valid up to 9/10/2026, 9/10/2026 to DG. These bank guarantees were given to them. This has been confirmed as per the requirement of the bank. I mean, sorry, the APDCL. Can you see page 142? Their chart. Out of the 7 contenders, we are at top in power, and they say estimated cost 12 crores 49, quoted value mine, then 3 were
You are
found.
the L1.
I'm L1. I'm L1. That was,
But this was as on 2/2.
that's on 2/2.
So this is prior to the,
Issuance of LOI.
no, issuance of the LOI. Okay.
And then after issuance of the LOI, even after issuance of the on 4/4, I mean 4/2, they wrote us. They wrote to us.
Where is that?
They wrote to us that you give these documents. Page 100, Lordship Returns.
They wrote to you on,
On 2/2 also, kindly see.
they wrote to you on 2/2.
Yes, on 2/2 also.
And you replied on 4/2.
I replied on 4/2. I stand corrected, right?
Page 118.
Now, Lordship may see.
So, Mr. Monto, what they did is, it appeared, they were concentrating on the question of abnormally low bid, asking you for certain justifications.
Then I
You
explained.
submitted your justification on 4/4.
4/2.
5/4, they issued, 5/2, they issued
LOI.
the LOI.
And thereafter,
6/2, you accepted it. Thereupon on 10/2, there is a confirmation that is again within 7 days by the bank to them, informing about the bank guarantee being confirmed of this amount along with additional security. Now they take a decision thereupon. They look here, all these things are okay, but you were not, your bid validity was not proper, taking into account that these affidavit, the affidavit which has been, or the document which has been, the work order which you have submitted is not signed by the superintending engineer on all these
CM or that.
things.
Yes.
And therefore, we reject your technical bid. It appears that this appears to be the chronology.
Yes. Malad, what happened?
There is one more communication.
Yes.
Communications were there.
On 2/2, we wrote to them on 2 grounds. Firstly, regarding the question of an abnormally low bid. And secondly, regarding the substantiation of the,
Where is this document which is attached at the document? Where is that? That document has not been attached.
yes, if your lordship comes to page number 145, the response to 2/2 for submission of documents is finally at page number 145.
Of your affidavit
No, of the writ petition.
of the,
Writ petition, page number 144.
we don't have 145 in the writ petition. We have only till 142. There is another. Yes, but this is the second one, na?
Yes,
140.
145. So this argument that has been sought to be placed for your lordship regarding the finality of this LOI
Your lordship has the language of this document.
Now, where is this document which you have issued? You see, kindly see page 118.
My lord.
Please find attached herewith a letter for your kind information. Then they gave a justification.
The letter, your lordship, is the letter at page number 116, your lordship.
116 written by?
Written by APDCL. Written to APDCL.
No. Where is your letter? I think
Oh,
this is
115.
115 is
50.
only, you are only asking for justification.
Justification.
You are not asking for anything as regard bid validity.
Lordship, if your lordship has the second but last paragraph from the bottom, also you are required to submit the supporting documents with respect to annexure 1E. Annexure 1E is the annexure pertaining to bid.
Calculation of the value component A of the bid capacity duly signed by an officer not below the rank of
DGM
GM.
prior to issuance of work order. So the issue of bid capacity was also raised on the second.
So
So,
here, this line,
my lord,
prior to issuance of the work order means prior to issuance of the LOI.
LOA. Now, an argument was sought to be placed before your lordship that the LOI and the LOA was same. Now, if the LOI is the same, on the 10th, your lordship, finally they respond to this document, our request to submit the documents, and that response is at page number
Page
145, 145. The documents are finally submitted. So I'll just draw your lordship's
So on 4/4, they only give the justification.
justification. Documents are not submitted. They say kindly issue us the work order. We are experienced. We have sufficient capacity. But documents are not submitted.
The submission of supporting documents.
Yes.
This is in consonance to the letter. No, these are different letters. Your letter is the 7-2.
7-2.
Where is the 7-2 letter?
7-2 letter, your lordship will find it 144.
Then too, we submitted, responded to it, page 145. What we have said, can you see there?
144.
144 is there later.
144 is 7.
144. Kindly come to 144.
My lord.
You are referring to the letter again to 22, which is at page 115.
My lord.
With reference to the above cited letter under reference, it has been conveyed to your kind regarding submission of the so and so prior to issuance of the work order. However, the same has not been received till now. And whereas the LOI has been issued and its acceptance is received by the letter number so and so, you are once again requested to submit the aforesaid documents on or before so and so that the work order can be issued.
My lord.
In the event of non-submission of the requisite documents within the stipulated timeline, the LOI is liable to be revoked without further communication. This is 7-2.
7.
Then they write a letter on 10-2.
10-2. 10-2. They submit the documents.
As per the tender document.
What we have said here.
The following technical exercise, successful construction of the commissioning of successful submitted in this connection years and so for the last 3 years to the qualified. Please note that order value of the MDC is more than the HP and the bracket, and the same order was also issued from your good office. Based on similar document. Now, can you come to 145?
My lord.
Their reply.
My lord.
And the said order was issued by your good office. Which reference to which one? The completion certificate.
The completion certificate.
I don't see annexure 1 to the document. This is the certificate they are saying. The work of so and so. This is the work. No,
This word cannot be considered your lordship because this is for a different financial year.
this is for 2025.
25. The year is 21-22. The financial year for which we
So
are.
this is more relevant.
This is no.
And bid capacity as per the tender document, we have to demonstrate bidding capacity of more tenders. So in this connection, we will submit the balance sheet so and so turnover annexer 1E and annexer based on the alia bid capacity is so and so. This is again 2025.
24. My lord, if I may just,
But this work order could have been taken into consideration, but not complete.
because if, since the highest year of the past 5 years is to be considered, and in their own affidavit, they had considered 21-22 as the reference.
They did not mention about this.
They mentioned these years, but for the purpose of calculation of bid capacity, they were relying on the financial year 21-22.
So now later on, they are asking you to look into the 2025,
Yes.
24-25.
24-25. They are submitting documents for subsequent years.
no.
One aspect of the matter, why I had taken your lordship to this document, because if your lordship turns to page number 147,
Wait. But Mr. Patel, if we let us see the term again in bid capacity, don't number here. See. I think tender was 2000.
it was issued on 11-9-2024.
11-9.
2020.
So they could have 25.
24.
So you could have taken up till 2000, end of, yeah, they mention as to what is the end period.
NPV.
So we see maximum valuable during the last 5 years, uptake may be taken as 10% per year, taking into account the completed as well as works in progress. Some still prescribed for the works for which to employ was invited.
So if your lordship has the annexure 1E which they submitted,
Where is that?
that document, your lordship, is at page number 102. The relevant portion is at 103.
And they did not mention about this contract of 96 lakhs, which they are mentioning out here.
These documents were not provided to us.
These documents were not a part of it.
Not a part.
These completion certificate or these are of 2025.
They were provided to us on 10-2026.
These are separate. These are not a part of the earlier.
They were not provided.
Well, probably learned friend not properly instructed on that. And listen, I'll have to clarify now, because we submitted the on 13/1/2026 itself first. First mail came to us on 5th of.
No,
January.
man, no, Mr. Mohanto, did you submit these documents which you have enclosed with your letter dated 10/2
Yes.
at the time of submission of the bid?
Exactly.
It couldn't
We
have been
submitted.
because you have not relied
Yeah,
at page
yeah.
103.
That is why what we have said is that we have already submitted, you are asking again, so we are again giving you.
No, you kindly come to 103.
103. 103. Yes. What it requires,
Here you have given up till 2023-24.
yes.
Where is 24-25 or 25-26?
No, that is, we submitted it later on.
No, no, no. Later on,
No,
no.
We just to show that we are walking.
No, and you
I'm
see,
relying on,
therefore,
I'm
you know,
relying on, yeah.
you see,
that document.
this aspect I have dealt with in one judgment of mine, Empire Singh Law. This aspect, how the bid capacity is taken, because this is the same formula, how it is done. Hey, Rana construction or judgment no? I think it is reported. Recently, it has been reported in GLT. The last GLT cover. Last GLT.
That they wanted,
Yes, Mr. Ghosh matter. And he has been filing matters after. This is one of the funniest thing what has happened. Let me there because today being a Tuesday, I have some luxury out here. There was a case. What has happened? Rana Construction came up with a case saying that look here, in respect to this particular contractor who has been now chosen to be given, he did not submit the existing works. And without the submission of these existing works, the bid capacity cannot be evaluated. Because you see, the bid capacity has to be evaluated how? What are the contracts you are doing presently also? Because you have to minus that from that. So he said that look at this particular person is the PWD did not listen to it. PWD then also went ahead and gave it to that contractor. So Rana Construction challenged him. There was a stay being granted. Then I was taking up the matter when I was taking bench. Then there was another matter where the PWD acted the other way. In respect to a particular contract which was there,
Same discrepancy.
that was not mentioned by the petitioner in his bid capacity because of the fact that the letter of intent at that point of time was not issued or something to that effect. But later on it was issued. So that aspect was also, now here they are saying that you did not mention this aspect, so therefore we are cancelling. Now you see the two different stands of PWD. So what happened, I took up that matter as well as this matter together. And then decided to that effect that yes, Rana Construction, you could not have done that because of he had a case and therefore I allowed those with petition. But I dismissed the petition where Mr. Ghosh was appearing. That's Empire Singh Law. It's reported. The funny part was this, that Mr. Ghosh went and before the division bench. Division bench issued a notice in the appeal, but did not grant a stay. So in the meantime, what has happened in view of my judgment, they went ahead for a second tender. He did not file an appeal. He did not grant a stay. So what happened when the second tender came, he said that I could not, he had to give some site visit certificate, not given, nothing happened. Then the PWD came up with the third tender. This third tender was challenged by Mr. Ghosh again. In effect, what he was trying to do was to stay that proceeding which was going on. That is the end. But in that case, I have duly taken into account how the bid capacities will be. Now, my question is, if you are saying that this is your bid capacity, it appears to be something mistake out here because here you are putting it zero. You had some other works in 2024-25. See how it is to be here.
but what they wanted,
You
they
see, the
last-
minus is value updated to the price of existing commitments. Now you are bringing in certain commitments which was not a part of page 102, 103. As on the date on filing of this particular on 13-1. As on that date, you had some existing contracts. You have given a
No,
wrong
what
bid
they wanted,
capacity.
my lord, what they wanted, those already completed. My
No,
experience. What they say,
no,
can you
kindly
say?
see B.
They have thought on
No,
that.
kindly come to 389. How it is. Value updated to of existing computer and ongoing works. No. Kindly see B. No, Mr. Mohta, can you come to B? B. 389B. value updated to the price level of existing commitments and ongoing works to be completed during the period of completion of the work for which the bids are invited. At that point of time, you did not have it. You had an existing commitment. As would appear from this annexure at page 100, and this one was there. This completion was there. This completion was there. These things were. Completion certificate.
That, basically, annual turnover of the bidder for the last three consecutive financial years shall be as per NIT. And the annual turnover must be certified by a registered company. That is what they want. So now in page 103, I relied upon these 3 years financial status. That is 22, 23, 24.
21, 22, 22, 23, 23,
24.
24.
These 3 years. Now they are raising the question. They are raising the question on that my financial status, which was I earned on 21, 22, and that was as a subcontractor, and I relied upon this. What they have subsequently said that because your documents are not sufficient because you are a subcontractor that time, therefore this will not be, this cannot be added to it, this cannot be relied upon, that is why it is flawed. What is the meaning? Flawed, imperfect, defective. That's much. So you could not have added, and this plea they have taken. My responsible submission is that is an irrelevant, totally non-existent ground, irrational. They could not have been in there because there is no condition in the contract that a subcontractor who earned experience as us earlier, they cannot apply. Therefore, the income I got.
So therefore, the thing is, we are to therefore interpret at 402. 402.
30,
402.
402.
Figures to be mentioned in column A shall be supported by relevant copies of the work order, LOI, as well as corresponding completion certificate
Yeah,
issued by the officer not below the rank of so and so of electrical utility.
exactly.
So therefore, you have a completion certificate.
Exactly. They have issued.
But they are now saying that a work order has to be issued by
Repetition.
CEO, DGM, and so, not as a sub-binding.
They are
So
ground.
that is the only question.
That is
That is the only question
Exactly,
because
that's the
you see,
crux.
as of now, the letter of intent may not be
Yes.
point. I'm not
What
not
does it mean?
accept.
Yes.
No,
Yes.
Mr. Monto, I'm not accepting your letter of intent. But the fact that whether the reason which was rejected is proper or not, I think there is a case.
Exactly. Exactly. That's the crux.
But there is no contract, no letter
No,
of accept. They may
I give it to your
again
lordship
consider
today.
this aspect. Taking into account there is no mention out here as regards subcontractor, or they may not, they also do not mention out here as to whether the order LOA, if there is an unambiguous, is an ambiguous. Now you find the judgment in Reliance, na? Reliance judgment, paragraph 34. Reliance, I think. Yes. Paragraph 30. Which one? Reliance? Full name? Huh? You have not taken out. Let me give it to you.
Speaking order. In my
No, Mr. Counsel, the thing is like this.
there is no mention of subcontracting. It says that the documents submitted by the petitioner are not acceptable for the purpose of calculation of annexure of the figures given in annexure 1. The lordship has that order. There is no mention of subcontracting in that order.
Which one?
The speaking order which is under challenge, there is no mention of subcontracting.
No, That order which is not there, the minutes I've seen it.
Minutes it is.
Which form
Yeah.
the speaking order you have taken
What
that as
the
a ground?
language used in the minutes, your lordship, is
Wait. Get that. Even like last GLP for us, we does that thing. Yes, 2007, 8 SCC, page 1, paragraph 38. Reliance Energy Limited versus Maharashtra State Road Development Corporation Limited. Right. None. I agree. It's true, I think it's reported. Okay. Hey, to the auction judgment to Reliance.
Talks about
2000.
legal certainty.
Huh?
That talks about legal certainty. They cannot. That is not, my lord.
Then it will be in violation of Article 14.
Lord, I'm thankful because lordship will see my submission is based on.
But I'm not agreeing to letter of intent.
My lord, I'm placing it for your lordship's consideration. And
No,
that's
I
not
was looking into all other documents because of the fact it appeared that they were prior to the issuance of the letter of intent, and their intention was very clear that these are the documents on which we are not satisfied with these documents, and you will be issued the work order only upon being satisfied with these two documents. One is the justification and the other is the bid capacity. They were saying. So I will interfere as regards the reason which is being assigned that this document could not have been taken. But I'm not they let them decide how they want to do it, whether they have any other good reason, they may do so. But this is the only thing I may interfere.
I'm grateful, my lord.
Only
My
to
case is this. Just two prong. My approach was two prong approach. Firstly, if lordship finds that my argument merits consideration regarding LOI, but the second is that is totally arbitrary.
No, therefore only on that aspect, because we are therefore to see, because nowhere it has been mentioned that a subcontractor cannot be, then it is not mentioned. But at 402, they have sought to give an interpretation to the effect that means double star. Figures to be mentioned in the column A shall be supported by relevant copies of the work order of the LOA, as well as the corresponding completion certificate issued by the officer not below the rank of so and so.
Yes.
Now, these completion certificates, now they want to say that order oblique LOA has also to be issued by the CEO. There seems to be an ambiguity. And if there is an ambiguity, it violates Article 14. This is the law. Only on that.
Yeah.
Rest you go ahead.
That's my ultimate. I'm grateful that that was my ultimate submission.
I think we can attempt to just convince your lordship. To
Yeah,
perhaps
see,
think of-
I am here to help both sides.
alert for once the minutes of the meeting, which is the reasoning for the
Yes, where is that?
911.
Just what has been incorporated in that after 1E. That is in page 402, that has.
Yeah. Finally come to 911.
Yes.
The tender evaluation was scrutinized the supporting documents submitted against the declared bid capacity. In this regard, the bid submitted two work completion certificate, one issued by the CEO of the area and another by SDM projects of area, wherein so and so has been shown as a subcontractor. However, the bidder failed to produce any work order issued to it against the two work completion certificates issued as subcontractor, whereas the bid mandates. Now, this particular document was given or not, which have been issued by his sister concern.
This document was went to us on 10/2/2026.
Which one?
The document where he's lying.
No,
This
no.
relevant, this document has page number
No.
170. Or 21/22.
70.
Yes. Page number 170.
This document was not given.
This document, along with annexure 1E at the time of submission of bid, documents were not provided.
This was not given.
Not given.
No, this is even better.
No,
That's
if-
why I wanted to say if this probably he was not properly.
This is my instruction.
Instruction may not be correct. Kindly see. We submitted it, page 100, lots of.
If this document was not given, then no help.
These documents were submitted. That is why we reiterated that we have already submitted the documents on 10. You are again asking, we are again.
They were submitted on 10.
No,
No,
10 2 would not
10
do.
I am not.
But
10,
where have you mentioned that you had submitted this document, this finally sheet,
yes.
this document? The bid, as per the tender document, we have to demonstrate here. In this connection, we submitted the balance sheet so and so, AIE and B. Based on the above the document, please refer to annexure 2 in this regard.
These
Based
annexures
on the
were
above
referred-
and above, after compliance with the query, we have received the LUI. Now we have been again asked to submit supporting documents against the bits of calculation. Even though the same has already been clarified before the opening of the bid. Please refer to annexure 4 in this. Further to
In fact, I have made a statement to that effect at paragraph number 8 of my affidavit.
Yeah.
Paragraph number 8 of my affidavit.
Before Lordship,
Is on-
kindly see.
For the opening of the event, it was seen that the submitted the required supporting documents in respect to a mixture of for the purpose of the recording. You are not saying it. Kindly come to paragraph 12.
Paragraph number 12. That is Paragraph number 12. That it is but pertinent to mention that in order to substantiate its quoted bid capacity of rupees so and so for the financial year 21-22, the petitioner was inter alia relying upon a work order in 11-21 issued by so and so, whereby it was appointed as a subcontractor for execution of certain works which were originally awarded by EPDC to Impar Infra, and completion certificates in respect of which were issued in favor of Impar Infra by Chief Executive Officer and the Assistant General Manager. However, it is pertinent to mention that no work orders were issued in favor of the petitioner from by EPDCL in respect of the said works. And as per the terms and conditions of the said tender, more particularly clause number so and so, yes, we did rely upon that clause of the article. But the fact remains that these documents are not submitted to us along with the bill. Because there are three components in lordship which have
Can come to paragraph 15.
paragraph 14.
13 also lordship is 30 here.
Now, the committee was constituted on so and so to examine the documents submitted by the petitioner for to substantiate its quoted bid capacity of rupees so and so of financial year 21-22. The said committee came to a conclusion that since the mandate of the tender document was that the figure quoted in annexure so and so had to be supported with both work orders and completion certificates, and the petitioner firm failed to substantiate such work orders or completion certificates issued in its favor, and instead were relying upon a certificate issued for granted to so and so, the same could not be considered for calculating its bid capacity. Further, Windpower Infra Private Limited had not obtained permission from APDCL while subcontracting the work of the petitioner firm, which was in violation of the terms and conditions of the work awarded to it. Accordingly, right minutes of the meeting with it so and so, committee resolved, the petitioner firm failed to meet the prescribed bid capacity criteria, and accordingly, it may be declared.
They have not mentioned there also that this document was not given.
In fact, no, it's mentioned in paragraph number 8, starts that if your lordship has.
You have nowhere mentioned a single line that this particular work order which was issued by its sister concern was not a part of the record.
Lordship at paragraph number 8,
Where does
that after opening of the price bid of the petitioner, it was seen that it had quoted an abnormally low price bid, and further, it had also not submitted the required supporting documents in respect of annexure 1E for the purpose of calculation of its bid capacity. For the as mandated-
understood? Because you are interpreting that it has to be issued by DGM. My question is, was this particular document enclosed, was a part of the bid? That is not clear.
Your lordship grants
Because you say that this particular document, you are not considering it. That's your submission. That is the reason which is being given by you. Now, my question is out here, that wouldn't it be ambiguous out here? Nowhere has it been mentioned that subcontractor would not be allowed.
that ground, your lordship, perhaps I am not.
No, if it is not allowed, then maybe the original contract may have been given by an electrical utility.
And-
So that particular, if the subcontractor is not being barred out there, then there is a vagueness as regards whether the completion certificate has to be given by the DGM or the work order has to be issued. Because you don't bar the subcontractors. It is a thing that his sister concern may be at mistake in giving him the subcontractor. That's a different aspect.
I know.
But my question is, therefore, I'm asking you, where is that particular, where have you mentioned that this particular document was not given? That is not your case anywhere.
No document was given along with annexure 1. That was my, I'll just.
Where is that categorical, one statement is enough. Say that no document was given. You are saying, well, then let us see, you have the records?
Entire records are not there.
No, but do you have the bid, technical bid, initial technical bid?
I do not have, I can have it at 2 o'clock.
Okay, we'll have it at 2, Mr. Mohanto. Let us see the records.
Still also for the time being, see this age, 100, first say 98. When they asked me first, I submitted before issuance, opening the price bid. That is why they are silent on. They only say, no, this cannot be applicable.
Page? No, you see, Mr. Pathak, if you can show that this was not a document which was there.
I know.
then it is okay. Then in that area, you have a case. But if this document is there,
Yes, and I understand what is.
then it appears to be a case of reliance.
There cannot be.
We therefore remand the matter for a fresh consideration, looking into it by removing this ground and then for reconsideration as per other terms if you want to do it. But we are going to hold it that it is an LOA. LOA has created no interest till now. But you see, the moment you are rejecting him technically, on an aspect, he has a right to be questioned that.
Hello, then if your lordship grants me 5 minutes time, I can get that instruction whether the document was there in lecture 1.
But had
These
it
are the
been there,
records.
had
2
it
o'clock?
been- Had it not
At
been
2 o'clock?
there,
2 o'clock?
or at 12, my lord.
You are going somewhere?
No, in another court, my lord. That was the first matter, old matter. I got it adjourned.
What I was given to understand that no documents were provided in lecture 1. I
Let us
just
see.
confirm that.
Let us see that.
Can it be at 12, right?
2. 2. He has to go. 12. It's not possible. You are asking 20 minutes.
Oh, sorry.
And Mr. Mohanta, you know, this court does not give any air for senior advocates. You are not there. Your son will argue. Your assisting
Then
counsel will argue.
lordship will accommodate us because
No
I am
problem.
behind the court itself.
I have already said this is the thing which is going to. The moment that document comes in, if the document is there
Yeah.
in the records at the time of submission of the bid, I'm going to pass that on. If there's no document, your case is dismissed.
But they have not said that this is not there. What they said that cannot be considered.
So therefore, whether the document is there or not, they will look into it.
And affidavit will definitely go in.
The word, instead of perhaps the word requisite was used at paragraph number 8, instead of the word all the documents. That was what I was given to understand.
Because because why it becomes very difficult, because on one hand you use this paragraph, the phraseology in paragraph number 8, and on the other hand you give a reason that you see he has been a subcontractor and all this thing. This creates a doubt on the mind as to whether the document was at all there or not. Because then why you are taking into consideration that document and not taking into consideration the other documents? Because the other documents were submitted subsequently. That is an admitted fact. So the earlier documents which were there, these documents were must have been there. Otherwise, why you are interested in the subcontracting business?
I'll get,
Well, from
if it is there, then I understand what is falling from
page
it.
94 onwards, I have submitted all these things. Since January,
No, at the time of submission of.
No.
You are
Mr.
asking me, I
Mohanta, January would not do. It has to be submitted on the last date of submission of the bill. Otherwise, if
definitely you
anything
do that.
else is being given, they would be violating it, and this is goes for, and their decision therefore for going for retender would become proper.
that otherwise they would have rejected my tender at that stage itself had those documents been not there. That is why actually. Otherwise,
Yes.
they have rejected my.
Everything will be clear like water.
So those are submitted.
Because I'll get the clarification. That will go to the crux of the.
Deeply applied.
Yeah.
At two. At two.
As for the last order, also we have filed subsection on 34/26 minute. And the respondents are directed to take instruction regarding,
What a payment?
no, lordship.
What? Which department? EG.
We-
Okay, the chief ingredients of it, forwarded the first demand to the secretary of lordship on 10/2/2026. So I need some time to get after the session to the secretary of lordship, because in the meantime, the access was in operation. So since it's been over, so I'll get that over.
The change of the council from Mr. Arando I got to Mr. Aran before now. Not change the fact that this court had already taken into consideration the same submission made on 7/3/2026.
Yes, Your Lordship. But still,
So therefore, we are there on 7/5/2026.
yes, Your Lordship.
Why no money?
Because in the meantime, this financial window has been closed, Your Lordship. So the secretary has received on 10/2, thereafter the update from the general secretary is awaited, Your Lordship. I've already asked for updation, Your Lordship, regarding this matter. Since the chief engineer already placed the requisite documents,
How much amount? How much you know we have sent for finance?
33 lakhs point 6612.
You pay interest on that. And that interest will be taken from the salary of the chief secretary.
You just get the impression, Lord. That'll come on next week. At least I get some,
Tell them. Did that? 11%.
they'll be taken up next week, Your Lordship. I'll get the instruction from secretary, Your Lordship. But whether they have forwarded to the finance department or not, Your Lordship.
I'm not concerned with the finance department. Finance department will do many things. I'm not concerned. You know. Did you have the administrative approval or not?
That's the issue. That administrative approval was not there, Your Lordship.
Then why did you award the work?
From our last.
At the time of awarding the work, you do everything. But at the time of payment, you don't. You can't do that. So this commissioner and secretary is the party. Okay, they will take it from his salary. Interest. From the date the court had passed on. Huh. Then the order was passed on. 5 years, 33 lakhs interest. 11% interest on the salary of the sub-commissioners. Art with so and so, the legal counsel appearing on behalf of the petitioner, Mr. R.R. Gogoi appears on behalf of the complainants. The present contempt application has been filed alleging willful and deliberate violation to the order dated 37/2021, passed in WPC number 1872 of 2020, whereby there was a specific direction issued to examine the claim of the petitioner within a period of 45 days. And thereupon, make payment to the petitioners in accordance with law and in the light of the directions contained in Council Ali Sutra. As no steps were taken, the petitioner was compelled to approach this court by filing the present contempt application on 7/5/2022. The record revealed that verification was carried out and it was found that the petitioner hearing is entitled to an amount of 32,66,123. And in that regard, a demand proposal has also been submitted to the Secretary to the Government of Assam, Public Health Engineering Department on 25/2/2026. This aspect was brought to the notice of this court when the matter was taken up on 7/3/2026. This court, taking into consideration the above, directed the counsel appearing on the learned counsel appearing on behalf of the respondents to provide an update as regards the status of the payment. Mr. Aram Gogoi appearing on behalf of the respondents today submitted that although such demand has been made, but on account of the window, what window? Financial window. Financial window. I'm told that the financial window, but see, if you want the money, then you have to wait, don't sleep at night, and then just see, we open for 2 minutes, then you have to, sir. And something like that.
Technically, I don't know, but they,
Technically, it's something like that. Wait, because we have to keep on waiting. Oh, it is open, then it is something like catching a fish. No, you have to, he's saying that financial window is open. So means I also have the knowledge about this. The financial window is such, you never know when it is going to, and when it is going to. It is not always open. It is open for minutes, if not seconds, not hours. What is it? Notify, but it doesn't go. It is open to you in hours. No. Admitted that on account of the closure of the financial window, the said amount could not be disbursed to the petitioner. Taking into account that the financial window, opening of the financial window is depends upon the discretion of the finance department of the government of Assam. This court inquired with Mr. P. Gogoi, the learned additional advocate general, who is also the standing counsel of the finance department, as to why, in spite of the demand being made, that too, which is in consequence to orders passed by this court, the amount has not been, the financial, on account of the closure of the financial window, the amount, the demand have not been provided by the financial department. Mr. B. Gogoi, the learned counsel learned standing counsel of the finance department, submits that he will obtain instructions in that regard. The registry shall show the name of Mr. B. Gogoi as the standing counsel of appearing on behalf of the finance department and Mr. B. Gogoi and in the cause list. The respondent in the PHA department as well as the finance department are directed to take active steps so that in the meantime, so that the amount to which the demand has been made of rupees 32,66,123 is released to the petitioners on or before the next date. This matter again on 15th of June 2026. 15th of June, long back, not May, June. And by the time if you don't pay, because it is observed that in the circumstance the payment is not reversed, this court shall also consider imposing imposing interest upon the erring officials, upon the respondent department, and such interest shall be recovered from the salary of the erring officials.
Making my deduction they were fixed as 5,000 per month and he made a prayer to reduce the amount. So they have reduced, my lord. But in fact, they cannot, my lord. They cannot, my lord, my lord.
There's no stay, they have been deducting.
Yeah, they have been deducted.
How much did they do?
Already, my lord, for till May, my lord. For till
He's a very, my lord, at present, he's
47
suffering
is
from,
not
he's a
my
stroke
lord.
patient also.
Happening. To tell his, he, according to his, her prayer, my lord, 30 installment, 60 installment, if it is deducted in 60 installment, already, my lord, 7 installment has been deducted.
47 now.
57. Now they are deducting 3,000.
Per month. As per
Total 60, my lord. They've already deducted 45, 47 installment. And now he's a stroke patient. His condition is very bad, my lord. Financially, he's suffering, my lord.
Forty-seven has been done.
as maybe 46, my lord, because in this fund.
46. Another 14.
He also reported by the related. Yes, that part of it must be clearly. But my lord, the order was 2022, that is challenged in my lord. 25. Well, I understand. That actually, that immediately, I like this, my lord, because they, that's what I was thinking.
And why did you say that you are going to withdraw and file a separate?
Yeah, because, my lord, I was just making a statement. The petition is not allowed, and in that case, I'll file a separate, but yes, still I'll challenge it, my lord.
Rafik Masi, what does it say?
My lord,
What does Rafik Masi say?
with me now, my lord. Your lordship, it will be some time, my lord. At 2 p.m., my lord, I'll continue. It says that, my lord, in case of grade 4 employee, my lord, it is not permissible. It is not permissible. Recovery is not permissible, and
After 5.
and
After 5.
and my lord, and in case it is the fault of the employer, then
Then
it is.
also, Rafik Masi moved into that because there were other judgments also in that regard. It is not the fault, then also you cannot be entitled to. But the fact remains out that you have got 181 and you have agreed to 180. They did okay, the deduction there and it's by them only were deducting.
Because he had to, my lord, fight against the, my lord, district judge, and he is only a grade 4 employee,
was
so
the
that is the
calculation
only.
made? Calculation made when? 2011.
20, yes, it was a 2011.
It was
because
calculation, my lord.
2000,
22, my lord, 2022. And they are saying that my lord, overdrawal was from to March 2011. They have, my lord, found out only on 25/7/2022 that there was an overdrawal, my lord. Since March 2011.
You have the Rafik Masi. Yes. Rafik Masi saying 5 years, right? No. We do one thing, we can stop from now. No more further debate. But the other matter is wrong. And you created a problem by yourself by filing this affidavit. Why will that? So and so the learned counsel appearing on behalf of the petitioner, Mr. T.J. Mohanta, the learned senior counsel, as well as the standing counsel of the Gauhati High Court, appears on behalf of the respondent number 2, 3, and 4. So and so appears for response number 1. The petitioner who is a grade 4 employee in the establishment of the district and session judge Lagan, isn't it? Now you are MSCT. You're working as where?
District and session
Huh?
judge my lord, was the
You're
MSCT.
working on the MSCT or the
Same court, my lord.
He's
District
a
judge,
night chowkidar, night chowkidar.
in the office of the district and session judge Halagan has approached this court by filing the present petition on two being agreed by on account on two issues by raising two issues. First, the non-consideration of the representation dated 13/12/2025. 25?
Hello?
13/12/2000, 13/12/2016.
Yes. I can also.
And the second, as regards deduction of an amount, as regards recovery made from the salary of the petitioner pursuant to the order dated 25/2/2022. It is pertinent to take note of that as on date, the petitioner is around 58 years old. Next. And is and would be superannuating in 2 years' time, isn't it? 60. 60 or no? 60. No? In 2 years' time. In the backdrop of the above, let this court take up the two issues raised by the petitioner in the present proceedings. The first issue pertains to non-consideration of the representation dated 13/12/2016. A perusal of the said representation reveals that the petitioner sought for exonerating him from charge 3 as well as drop all charges against him in DP case number 1/07, and also sought that the petitioner, that no penalty should be imposed upon the petitioner. The record reveals that the said DP number 1, case number 1/2007 already stood disposed of on 23/12/2016, whereby penalty has been imposed upon the petitioner withholding 3 successive annual increments. With a further observation that the petitioner would be allowed to draw the area pay of his suspension period, excluding the subsistence allowance already drawn. Under such circumstances, the representations were submitted on 13/12/2016 had already become infructuous inasmuch as the disciplinary proceedings have already been disposed of, and there is no challenge to the disciplinary proceeding before the appropriate forum. The first issue, so raised by the petitioner, hence stands rejected. The second issue which is raised is on the question of recovery which has been sought to be made from the petitioner on the basis of the order dated 25/7/2022. A perusal of the said order revealed that in the year 2022, it came to light that the petitioner who, you are not there, you are in the office of the MACT.
MSCT, my lord, your lordship will kindly see, member MSCT come district and session judge. Same office,
Salary
same.
is paid differently in different heads. Salary, if you are in MACT, because the MACT judge is as a, because it is in a different head. MACT is given differently. Here it is being given different, isn't it, Mr. Gugoi?
But same
It will be
authority,
different
P
heads.
64.
MACT,
Kindly turn to page 64.
That is under state. Yes.
That is there.
MSc.
MACT is a different head. So we have to therefore pass an order to that effect. No?
Yes.
Because this order is being passed specifically by the MACT member.
My lord, MSCT member come district and sessions judge. Page 64, my lord.
Then you, later on, you will have a problem, I might. It came to light, a perusal of the said order reveals that the petitioner that upon verification of the acquaintance role, acquaintance, AQUINTANC role, with the pay bill for the month of June 2022, it revealed that the petitioner, who was a peon in the office of the member MACT Hailakandi, was drawing salary on the basis of PB 24,110 with rate pay of 3,900, wherein, as per the service book, it should have been PB 22,490 with rate pay of 3,900. It was also noticed that the overdrawal had been running from the month of March 2011, while the bill was prepared taking PB 6020 with rate pay of 1,500 instead of PB 5680 with rate pay of 1,500. And accordingly, the fixation of pay as per ROP 2017 was calculated on the resultant basic pay of the incumbent. It was also found that on account of this mistake being committed by the officials, there was an excess payment made to the petitioner of an amount of between 1,81,339 as overdrawn by the incumbent, by the petitioner, as on 30/6/2022. By this order dated 25/7/2022, therefore, it was therefore observed and directed that the said amount of rupees 1,81,339 shall be realized in 37 monthly installments from the salary of the petitioner. And out of these 37 monthly installment, the first in respect to the first installment would be rupees 1,339. and the remaining 36 installment will be rupees 5,000 only per month. The petitioner, on coming to learn about the said order dated 25/7/2022, submitted a representation to the District and Session Judge Hailagandi, requesting that instead of recovering the amount of rupees 1,81,1339 in 36 installment, the same be done in 60 installments of rupees 3,000 each, after deducting rupees 1,0339 initially. As per the request made by the petitioner by the representation dated 5/8/2022, the deductions were made from the petitioner's salary by recovering the said amount. And the petitioner accordingly was paying the said and the petitioner and the petitioner did not raise any objections then. However, subsequently, the present petition has been filed before this court. In the year 2025, or filed before this court on 24/3/2025, whereby the petitioners challenged the recovery made of rupees 3,000 per month from the salary of the petitioner. This is the second issue. Mr. T.J. Mohanty, the learned senior counsel, appearing on behalf of the respondents, submitted that the fact that the petitioner that there was a wrong fixation of the salary of the petitioner and there was an excess payment to the petitioner of an amount of rupees 1,81,339 is not is an admitted fact, and the said aspect would be seen from the acceptance of the order passed by the learned member MACT on dated 25/7/2022 by the petitioner in his representation dated 5/8/2022, and on the basis of which the deduction which was sought to be made at the rate of rupees 5,000 per month was reduced to rupees 3,000 per month for 60 months. With effect from August 2022. The learned senior counsel submitted that in the meantime, 47 installments out of the 60 installments have already been deducted. You see? 46/47 installments out of the 60 installments have already been deducted. And as the deduction has been made upon due acceptance by the petitioner. And it is being done at a rate which the petitioner had represented. This court may not like to interfere with the recovery proceedings which are going on. Per contra, Ms. S.B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the petitioner that the wrong fixation was not on account of any fraud or misrepresentation by the petitioner. It was done by the officials concerned. And the petitioner had no hand in that. The learned counsel further submitted that the petitioner is admittedly a grade 4 employee and would be superannuating in another 2 years' time. The continuation of the said recovery proceedings against the petitioner is grossly iniquitous, and accordingly, this court may interfere insofar as further deduction from the petitioner's salary, inasmuch as the petitioner is having great difficulties in running his day-to-day affairs. The learned counsel further referred to the judgment of the Supreme Court in the case of State of Punjab and others versus Rafiq Masih, whitewasher, etc. Reported in 2015, 4 SCC page 334. And more particularly to paragraph number 12 or 18. More particularly to paragraph number 18, 17. What is that you are looking into? I am looking into another judgment. He is giving me the INC. Where is the problem? Very good. And more particularly to paragraph number 18 and the subparagraph along with the particularly to paragraph number 18, wherein it is mentioned as to when it would be impermissible for the employer to recover this court have given an anxious consideration to the respective submissions and have also taken note of that the petitioner had approached this court at a very late stage. However, it cannot also be lost sight of that the petitioner is a grade 4 employee and has limited material resources. Which would have aided the petitioner with proper legal advice. The Supreme Court in the case of Rafiq Masih Supra observed that there may be many circumstances of hardship which would govern employees on the issue of recovery, where payments have been made by the employer in excess of their entitlement. However, As a purpose, for the purpose of ready reference, the Supreme Court summarized some of the situations. Paragraph 18 of the said judgment being relevant is reproduced here in under. The situations which have been mentioned by the Supreme Court, the situations, the circumstances under which it was held by the Supreme Court to be iniquitous, inter alia, related to recovery sought to be made from employees belonging to class 3 or class 4 services. Recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery was issued. As well as recovery sought to be made as well as when the court arrives at the conclusion that recovery if made from the employee would be iniquitous or hard or arbitrary to such an extent as would far outweigh the equitable balance of the employee's right to recover. In the instant case, it would be seen the above three conditions apply. Inasmuch as the petitioner herein is a grade 4 employee, class 4 is a grade 4 employee. Secondly, it is only in the month of July 2022 it was noticed that since March 2011 there has been an excess payment. And under such circumstances, the recovery which has been sought to be made for the period prior to 5 years from the date of the order dated 25/7/2022 has to be held to be would come within the ambit of clause Roman 3 of the paragraph 18 of the judgment of the Supreme Court in Gauhati. In addition to that, this court also finds it very peculiar to observe that the petitioner is going to retire in 2 years' time. And the continued and the petitioner who belongs to the grade 4 service is going to retire in 2 years' time. The continuation of the recovery would be grossly iniquitous and harsh. And accordingly, would violate the mandate of Article 14 of the Constitution. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. Number 1, the representation dated 13/12/2016 had become infructuous in view of the order dated 23/12/2016, whereby DP case number 1/2007 stood disposed of, thereby imposing the penalty upon the petitioner. Number 2, This court is not inclined to interfere with the order dated 25/7/2022, whereby there was a decision taken to recover an amount of rupees 1,81,339 from the petitioner. Consequently, the recovery which have already been made till date is not interfered with. However, it is the opinion of this court, and accordingly this court directs that there shall be no further recovery from the bills, from the salary of the petitioner henceforth. This court further directs the respondents herein to duly intimate the directions so passed by this court in the present order, a present judgment to the accountant general, to the finance department. To whom should it be intimated? She has also made the mistake not making the finance department a part. It has not made the finance department, the accountant general, because this will be then have a problem with your finance. Shall also intimate the finance department as well as government of Assam, as well as the judicial department. You are there. You are there. No? Yeah. The respondent number one is further directed to intimate the office of the accountant general Assam about the present judgment, and there is a specific direction that there shall be no deduction from the salary of the petitioner, no recovery. There shall be no further recovery made from the salary of the petitioner with effect from May. You got your salary this month?
This month,
From May 2020.
Two and three, one and two, madam. Sorry, three and four. Not two.
Okay. Yes, what is the matter about?
My lord, we have challenged an award of the paper court. Lord, whereby the petition, respondent number one was directed to be reinstated in the petitioner company. But my lord, facts remain. He resigned from us, from our company somewhere in 2008. Thereafter, full and final settlement regarding his payment was with us, and he joined another company. And that company,
You was working at?
I was working Bata store, my lord. This is Bata store at North. As well as the contractual employee as you were working. Contractual employee. Contractual employee.
So I am getting that work. He is gonna manage them.
You are working as what?
So I was working on a day-to-day.
Temporary
basis,
salesman who was working.
as a temporary employee. So 2008, I was engaged on a day-to-day basis. As a temporary employee. On 2008, on the enrollment, my case is that on the enrollment of giving permanent thing of my post office, I have to take the signature income paper, which has been parameter my resignation letter, and also a appointment letter was issued to work, company work under a contract law. It is a contract level. I have, thereafter, I have finished the issue for the, from the, that the fact case was introduced for the labor code one. The labor code has same.
But you have not been given any temporary appointment. You were always remained as a temporary with us. What is your right? But
I was,
are you entitled for weekend? You may be at best entitled for weekend. What other right do you have?
that the labor code of the same one issue of whether compelling that petitioner, that workman, to work under the contractual employee is fair or justified.
No, my lord.
whether the management Bata India Limited is justified to compel their old employee who has joined prior to 2008 in the company to join in the outsourcing unit. It was the terms of reference.
But where is the term for reference?
That page is 128. If not, then whether Bata India Limited is justified in terminating the age coupon without assigning any reason.
Whether Bata India is justified to compel the old employee who had joined prior to Iman in the company to join in. If not, whether he is justified by terminating without assigning.
Now, on 15/11/2025, Devako asked award for reinstatement in service role. But they have not reinstated, and after a lapse of 2 years, they have filed the requisition. In this requisition, I have filed on affidavit that I have not been gainfully employed in any other authority. So this honorable was on order dated 27/2, 2000, 27/3/2019, direct the petitioner to grant benefit under section 17B. Thereafter, I have received some amount, but from July 2025, they have stopped paying that 17B amount. The matter was dismissed for non-prosecution. Proceed has dismissed that matter. Thereafter, they have filed two petitions, one for restoration and one for delay, condonation of delay for restoration. Both delay as well as restoration I did not put protection on the understanding that they would clear my entitlement under section 17B. They have also made assurance. That was also one court has also pleased to record that in the meantime, the management would pay the all 17B benefit to the employee. But till today, I am deprived of that benefit. That order dated 19/1/26 and 13/3/26, there is a mention. As on that, 5,936 rupees is due to me under section 17B.
Document kindly see page number 25 of the repetition, my lord, whereby he has resigned from us and thereafter he joined a separate company, my lord. Though he is saying some agent he was joining is not so many. a record was called for, when it was dismissed for default, my lord, there was a direction that within 30 days it has to go back, my lord. Probably accordingly, the record has gone back.
So you were appointed to join in the outsourcing. Then
I was,
you were a temporary employee. What right do you have?
I was on the promise of making,
To make you a permanent in Bata. So you submitted your resignation. This is the
Yeah.
fact which you have duly admitted. Now, whether that resignation letter had anything to say or anywhere to say that this is on the basis of that I'll get a permanent job. So, and how can oral evidence be taken in respect to that when the documentary evidence shows that you have resigned?
yes, on
You
document.
will write in a letter that I recall my resignation, but once the resignation has been accepted, wouldn't that be amounting to termination?
No.
The cessation of relationship.
No, there is no that letter.
Huh?
But there was some admission on the part in cross-examination. I have also checked that lecture is not here. I have also the copy of.
But did the management witness admit that yes, I gave allurement to him that you resign and make you permanent? No.
That, no,
It is being done on the basis that this statement which has been made in the written statement made by the workman was not denied specifically by the management. And
Some in cross-examination, I forgot, but I also that first part is not also available with me today. In the record, I have seen some admission that I forgot.
But my lord, in the written statement of the management, as well as in the evidence submitted by the witness, they have denied that they do not have any compelling him to resignation, and he joined the second company voluntarily. Though he was on deputation in our shop by the team list private limited company, that is also on record.
by the team lead.
Yes, he was on that. There is an observation in the award.
Team lead appointed him.
Yeah, he was on deputation. He was on deputation. There
How
is
can he be on deputation? He has to have a
well, that's what they're similar.
No, not that.
no, no, Mr. Counsel. How can a person be on deputation if he doesn't have the original post? What we understand by the term deputation is a person has to have a lien in the original post. Will the original post
Yes.
be on deputation?
Was placed under the job. Yes, correct.
That particular company were appointing him as our outfit. This is the first question. But the fact that you have been terminated, no,
We
your
have- he has resigned.
relationship has ceased upon acceptance of your, what I mean. Can it be looked into in this manner by which it has been done? And did you terminate him? No. Termination is being done by team lead. So therefore, the reference appears to be some problem.
And team lead,
Team lead is not a party.
yes, that objection also raised in our WA.
Then what to do? You have the cross.
Not with me, my lord. I have entered after it was dismissed for default, my lord. I have only the documents obtained in certified copy only from the court record. Earlier set of counsel, my lord.
But there being a direction upon you to pay the 17B, why have to pay?
I inquired, means that, we, the Tata has no record of this particular employee with us. They will pay. But, the legal advisor who is in touch with me, he says they will pay if there is a direction, but we do not have any record. about it.
The direction, they are the 17B banks. We are not hearing to this direction.
What I was,
Till 2025, I
First
was
one,
getting from the PATA. Till 2025, I was getting. But after 25, after institution, they have not paid anything. An area amount from the award in the date of filing this petition, they have
Well, understood. You, when you have not been paid.
I have touched this point. That from November 2015 to December 2015, and in 2016, 17, 18, I have not paid. And from January, February.
No, that was not that period. When was this matter filed? 2017. 17B will start from when?
From the
The
date of award.
direction must have been passed.
From the date of award. From the date of award.
17B.
Yes. From the Kakumani as well as Jana Bank, so we got the bank.
On the date of the award.
Award. That direction from this code from 17 to 2019, but before that period, I have not been paid.
the last wage is entitled to, but with us, last wage is in 2008. With Bata, his last wage from Bata, he was getting somewhere in 2008 only. So pay that. What I was proposing to my liner firm, if the matter can be sent to mediation and in a lump sum amount, we can settle it out. That also proposal I gave it.
17B, there is a direction.
No, as a whole entire matter.
If there is a mediation, that will happen. If you settle it out, otherwise, see, you have a case.
Yes,
But I'm not going to allow you to petition because we are not complying with them.
that
in the way. You have a case, but I'm not going to.
for that only when understanding that I requested, if it can be.
You have to pay 72 days a direction. You know, putting the reports, you have that, you don't, I'm not going to call for the report. Get your evidence, because that is the only evidence which is there. Because otherwise it is an admitted fact that there was a resignation. It's a thing, it's a different thing that there is an allurement. So can that allurement be proved in this manner? Very difficult. And once that is there, without the team leasing who had appointed you, if they have then terminated you, maybe Bata may have control over team leasing.
Under Contract Labor Regulation Act.
Whatever may be, team leasing, they may have a contract there with them. But whatever may be, the Bata has in the different entity, team leasing has to be made a partner. The workforce.
I was also taking on ground that change of my service condition from Bata principal employee to a contractor without my knowledge. That was my done, whether it's successful
Understood. But the fact that you have resigned
on record.
on record, problem lies there. And you, we have resigned from record. That's a documentary evidence. And the documentary evidence by way of oral evidence, you cannot, unless you have filed an FIR or something to the say that this was done on the force, on the four, or fraud or something to that effect. But there's a collateral challenge to this particular document. But in a labor court, the court is only going to look into it as to whether that document is there or not. The document with the see that the adjudication is a quasi-judicial adjudication in a labor court compared to the civil court or the criminal courts. Anyways, we have to rise now, not to spoil your lunch. 2 o'clock, we are going to have the other matter. Then again, in the meantime, if you get some. Or should I send it from mediation?
No, if he acts, I'm agreeable.
mediation. Are you going to settle it with him?
Take instruction, but my plan to not getting anything, yeah, that's 73 the trial.
If you can go for mediation,
To get them paid from amount, then I will also take my instruction. Key order has been hired.
Some payment in the
Remember-
meantime.
You do one thing. Come up here with instructions. We are having it next week. One-time settlement, 6 lakhs. You give up, you also finish.
I'll take it.
6 lakhs. No more. Because you also know. They, as of now, the Bata cannot give you any employment there. There is a different set of it. Bata, which was then at that point of time, was different from now. Bata has now become a different entity altogether. After the opening of these K shops and all. Bata, which was there at one point of time in 2000. In fact, Bata is interestingly, it's a Czech company. Are you aware?
No, no.
They're appearing. It is a Czechoslovakian company, Czechoslovakia. Then it was a company from Czechoslovakia. They came over and they made everything out here and they became the, because at that point of time we had a good relationship with Russia, Czechoslovakia, we had to the field. So this was the company which came over. They still have shops out there in Czech Republic, you know. So this is the, but Bata has changed after I think 2011 or 12, they have changed altogether. It's a different thing. Final settlement, you do it at 6 lakhs. Both of you, we have it next Tuesday, 2 p.m. And just find it out as to whether you get this instruction 6 lakhs. And then we close this everything. Sending it for mediation is unnecessary. There is nothing in there. But you have to also understand that this is going to happen. And Mr. Counsel, you also ask your client to do so, taking into account there is already a 435 amount, which is, as per the directions of this court, is to be paid. So therefore, this amounts to a contemptuous action on the part of your management. So therefore, you ask them to settle it out. 435 plus another 165 will make it 6 lakhs. So 6 lakhs of one time. You also don't have a good case out here. So 6 lakhs next year. Heard in part is the matter. So and so.
Madam, may I pay for 14th of May, madam, instead of 12th, 13th?
14th of May. 6 lakhs.
Yes,
Not
madam.
positive. Not begin. Go to.
I'm all right.
This is the technical group. Documents are not there.
The document.
Back your lordship, I have just had a conference with the concerned officer, one of the concerned officers. Along with the bid, no documents were submitted as far as annexure 1A1 is concerned. Then we wrote to them that kindly submit the documents. Then firstly on 13th of January, they had submitted these documents.
Huh?
They had submitted certain documents on 13th of January.
No, no.
Then also this document was not brought on record. This document came to us for the first time on 10th of February.
Here also, we don't find that wind power document.
That is because the document was given to us for the first time on 10th of February. So it is a part of our affidavit,
That document was only given on
10th of February 2026. Page number 17. Technical documents in order to show their technical capacity, which they had provided along with the bid. I marked in a pink flag a lot towards the right side. It's towards the end of the bid.
You see my judgment, that one, none of us,
I'm carrying the judgment. I have.
I have specifically dealt with them. He did not mention that. This is a similar clause. Because without that document, you cannot. Now they have given the completion certificate. These are subsequent documents.
These are documents enclosed along with the bill, but not for that financial year. This is for determining their technical capacity.
So they submitted the bid on 14,
Was actually subject to us on 15th.
15th.
15th. Yes. Article.
And what was the bid capacity required?
Estimated bid capacity. 12 crores, 49 lakhs, 12,131.
Mr. Mohanto. To help you. You did not submit that document. You did not submit that document.
No, not. And, and, why? Because I believe that the records cannot.
No, this is as per your serial number. I'll see you have an index. What you have submitted is this document. I'll see this document which you have included.
Only document we submitted up on that.
Page 149 is the document which you have submitted.
One 149. This is the. In fact, what
This one you have.
the completion certificate. Whether it is clear or not, but then
But this is not what is there in annexure 1E. Your annexure 1E is different from this. I'm helping with this.
the first move.
I think Mr. Mahanta, I think now I think no.
I think
Mr.
so.
No.
That down itself, my tender could have been legal. Authority, what they have said. What they have said in the minutes, that minutes would be taken. They say that upon examination of the relevant provisions, before that.
In fact, the authority concerned could not have even taken into account those documents.
No,
Yes.
because, why I say no? Because
If
only
that,
one
if those documents would have been taken into consideration, the number to L2L, LP could have very well approached this court for setting aside. Taking into account that your thing has been taken.
well, that doesn't get the right, because I submitted those documents which were required as per the NIT. And that is why they found me responsible. And there, they approved the bid on 2-2, can you see that? Eh? No, that's not one. T24.
Remaining, I think you should make submissions before the division bench.
Before that, let me just
No,
verify,
No,
because
Mr.
how,
Mahanta, sorry.
because
sorry.
these documents also
No, I'm not going to look.
Cannot-
Remaining is for division bench.
cannot, cannot say something which is not.
No, Mr. Mohanta, first of all, you have made a submission before this court that you have made that document.
Yes.
Yes.
Well,
You have enclosed that document, you have made a submission before
That's my
this court.
case.
And in fact, that document is not there.
That's why I'm saying,
So
Malak,
therefore, I'm saying
don't
that
believe.
this is a case by which you have tried to mislead this court.
my sport submission, had it been the case, the authority
Maybe,
would have.
I'm not saying that the lawyer is
would have
misleading,
mentioned-
your client was misleading this court
Well,
by putting it, that particular
you see-
document was there. Sorry.
Page 110. 110, this is their document. Can you see 112? They have somebody, they have reported, they uploaded on 2. They have shown that all the tenderers
No,
status,
you don't have a right.
status was shown. And then
Remaining is for that.
affected
But Mr.
finance,
A.K. Mohanta,
Nothing more, madam.
senior counsel assisted by so and so.
may I show
No,
one more?
no, sorry, Mr. Mohanta, remaining is for division bench.
Malak,
Sorry.
in that case.
Mr. Mohanta,
Malak,
no, Mr.
I-
Mohanta, nothing doing.
I will.
Mr.
I will allow-
Mohanta,
I cannot.
I found out everything that which point you have, I found out everything.
why I
This document
to
is
see.
not there.
Malak,
I'm very particular on
They
this.
even
aspect.
accept. They even accept this particular document. as
This is
page
the
one.
most, but this is the vital document. There is no supporting document in pursuance to annexure 1A, 1E.
1E.
1E, there's no supporting
It
document.
was to support my financial position. I have given it. It was there, but they insisted that we need more. Then we submitted on 10th.
That document
And-
is, Mr. Mohanto, that document is not there,
10th, my lord. Whether this document is there, I don't
not there.
find out. On 10th, we submitted only this one, page 173. Otherwise, this page
You may have
174,
now a
this
right
was
of,
already there.
you will get a right of appeal because obviously the division bench will consider the
Hello.
appeal,
My lord,
considering the amount of cost I'm imposing on this case.
Lord, document can be, bear with me for 2 minutes.
10 lakhs.
My lord, this document was 174.
No,
This should
sorry.
be on record. This is, if this is on record, at page 174. This was submitted to the people.
Page 1.
74. This meets the entire requirement. If whole thing is there, was submitted on, well, along with the bid document, page 174. And page
170.
174. Which all work orders, everything is submitted on 174.
So,
Only other document.
no,
which was-
this document you have not relied upon.
No, this was the like,
Where is the work order?
work order is given here, Mala.
Where? Where have you
At
enclosed
page,
the work
page
order?
170.
Huh?
Page 170. This work order, it was to me as a subcontractor. That's why they have taken this down.
Mr. Mohanto, am I not being able to make you understand this particular document at page 170 is not found in your bid? That is what I'm saying. If this document would have been there, I would have allowed your petition. That is what I have been saying all along. This very document is not there. You could have very well relied upon this document, which you did not, maybe for whatever reason, at page 149. This document you should have relied upon. This document was very much there, but Annexure 1E contains this document at page 107. And this document had to be given. You should have relied upon this. Problem lies there. Therefore, I'm saying that you have been not properly instructed by your clients.
Even there.
Even then, they, Mr. Mohanto, you know the scope of 226.
That is why.
Sorry.
Let us not go wrong on that.
Now, therefore, you will be submitting a fresh tender. They are going for a fresh tender.
Bids have already been submitted, technical bids have been approved.
You have submitted, no.
No. Let kindly see. If those requirements were fulfilled, when they asked for further documents, then we submitted one more document that is only.
No,
at
there
page
cannot be
130.
any further document to be
No,
submitted.
when they asked that you submit.
That's a different thing, but that goes very principles.
So therefore, on that count, my responsible submission is that when they wanted the required documents to be submitted, those were there. For further satisfaction, they wanted, we submitted. Otherwise, they would have rejected my bid at that time itself. That's why at page, that, 110, I have submitted. They have shown me as successful, which is the status they have shown on 2-2. On 2-2. Otherwise, well, I would not have come for you. Why? I have no ground to stand if I have not submitted the documents. They found me 2-2 on that day. They found me on 12-2. 12-2. They found me. This was approved date on 12-2. And then they asked me to submit. Then I submitted. Then also I submitted. When they asked me. Therefore, my response submission. my
How
lord.
did you submit? How did you submit this document?
Initially, hard copies. And
No,
subsequently,
this document. How did you submit these documents subsequently?
subsequently when they asked me.
So this couldn't have
So
been there in the e-portal.
So,
Couldn't have been, you see, all documents have to be submitted through e-portal.
will appreciate when they ask me that we need further satisfaction, you give us those documents. Then we can submit on this because they have not taken the final call if they say it. Therefore, we submitted. Yes,
Mr. Mohanto, I make it very clear to you, I'm dismissing your petition. Either there are two ways out. either I dictate it in the court or you want, I should put it in the CAB. I am not going to make a CAB. I want to dictate in the. Now, if you want to make it a CAB, I can make it a CAB, get the judgment after 3 months. In the meantime, I'm vacating the interim order, let them go ahead.
My lord,
Either of it.
my lord, I cannot ask that your lordship should.
No, Mr.
Should go-
Mahanta, Mr. Mahanta, this court has already made up its mind. I'm not
Therefore,
going to
lordship,
change
can
it.
you see,
I'm not going to
at
change
page
it.
one
I'm going to
forty-five
dismiss it.
also, we have indicated and we have submitted.
Yes, I may be wrong on appreciating the document, but I'm not going to interfere.
No,
I'm going to dismiss it.
as I submitted, I was myself taken aback when your lordship says in the record it is wrong.
Therefore I'm therefore saying, your client should have instructed your assisting counsel in a better manner that this document was not made. And therefore, this document, which is your fulcrum, the fulcrum is not there. This is the main document. If this document, I therefore mentioned it in the earlier in the first start. If this document is there, I'm going to allow your petition to that extent. But without this document, this court is not going to permit, because this would be allowing this document to be taken into consideration by them. Now, by this court, would amount to this court violating Article 14, who are the other petitioners,
No.
other persons.
The comment was that work order and the certificates certified by the officer. Certificates are all there. And we, along with
Work order is not there.
work, along with that, our instruction, my instruction was that this document was submitted, hard copy, and this was repeated.
Now, I am not required to submit by online mode.
In the seal cover. It was submitted in seal cover.
In the seal cover,
Ah,
this
yes,
very
well-
document is not a part of it. Kindly have a look at the report.
I have believed your lordship, lordship has, I did not have to go through.
No, have a look. Give it to him. Have a look at it. Ask him
But,
to-
but they,
that
that
document
is why I say I'm taken aback. How could it happen? Because seal cover,
What document? Kindly see the document at page 200. This is a very relevant document, which you should have become a part of Annexure 1, which is not.
only document which was submitted on 10th is at page 170. That is the only document.
10th has no business out there.
Then
Once,
when they are,
because you are not allowed to, because asking the, in fact, what they were asking for, in fact, that is also not permissible. What they were asking, that they wanted to give it to you because maybe because
what they are
you have quoted 9 crores 99 lakhs, which is 19.47% below that. Then that must have been the reason they may have been insisting upon.
Yes, we have shown that. And,
But later on, the thing appeared out there that because you have to also understand the document on second. The document on second is the main problem.
But in fact, the document at page number 174.
online documents, they have taken out. Down with
No, this is signed copy, original signature.
It's a signed copy.
First page, original signature.
There is a serial number. Have a look at it. As per serial number. That is why it took me time to look into the entire thing. The document at page 200 is there. This should have been the document which you should have applied. You have not applied that.
I could 170, that was sufficient. That's why I'm agreed before this one. So that is fine.
That is why I'm saying, you have been properly not instructed on this aspect.
No, it was time and again asked. Because the documents are very much hard copy, you were seal covered, sir.
Because this is the hard copy. This is not the uploaded copy, this is the hard. And this is maintained with serial number. Chal. Heard Mr. K.K. Mohanto, the learned senior counsel assisted by Mr. K. Mohanto, the learned counsel appearing on behalf of the petitioners. Mr. K.P. Bhagat, the learned standing counsel of the APDCL appears on behalf of the respondent numbers 1, 2, 3, 4, 5. The present petition has been filed by the petitioner, assailing the speaking order bearing letter number CGM oblique DNS bracket close oblique APDCL oblique LAR oblique HPCL comma Omordonga oblique 2025-26 oblique 88 dated 9/3/2026, as well as the notice inviting tender oblique retender by NIT dated 10/3/2026, published on 11/3/2026, and for other consequential directions. The brief facts which led to the filing of the present petition are that the respondent number 1 to the Chief General Manager, second DNS, APDC, issued a notice inviting tender dated 11/9/2025 for construction of 36 kV dedicated to the from 250 kV Kolakati DSS to 80 HPCL project at Komodonga under Pasudao ESP under deposit work scheme on 13 mode. The estimated cost of the project was rupees 12 crore 49 lakhs 12,131. And the period of completion was 180 days from the date of issuance of the work order. The same notice inviting tender contained various sections. Section 1 was the notice inviting tender. which stipulated the tender download start date to be 12/9/2005. Meeting date up to 1400 hours on 16/9/2025. Reach submission start date on 19/9/2025. Reach submission end date up to 1400 hours, 1600 hours on 25/9/2025. And the technical bid opening date on 26/9/2025. It is categorically mentioned in note 2 of section 1 of the notice inviting tender that the bids must be submitted electronically tender www.assamtender.gov.in in two parts as techno promotion bid and price bid. Apart from that, a copy of the technical bid had to be submitted in a sealed envelope subscribing A, tender number, B, date of the bidder with the address. It was stipulated that only bidders who were found acceptable in part 1, bracket B, bracket technical, with adequate bid capacity shall be considered for operating or opening on the price bid. The date and time of opening of the price part 2 bid, bracket price, shall be communicated to those bidders whose bids are qualified for opening. Section 2 of the bid document, no other bid document, is with the heading 10-day inviting proposal. This is section 2 contains various terms and conditions. Clause 5 of section 2 stipulated the basic qualifying requirements. Subclause capital A of clause 5 is in relation to technical. Subclause capital B of clause 5 relates to financial, and subclause capital C of clause 5 is the bid capacity. Clause 6 equally the requirement of entering into an agreement by the successful bidder within 7 days from the date of issuance of the detailed work order, bracket LOA, bracket 2, failing which the LOA shall be treated as cancelled without further communication from APDCL. Clause 6 being relevant is reproduced during under. Clause 7 of section 2 is in respect to performance guarantee. And the requirement for submission of the performance guarantee, which is to the tune of 10% of the contract value, of actually valid for a 60 days beyond the 60 days of completion of the project as per LOA. Clause 8 refers to additional performance guarantee in the case of abnormally low bids. The said clause 8 being relevant is reproduced hereinunder. Clause 11, submission of bid. The perusal of the said clause more particularly the later portion of the said reveal that upon non-acceptance of the letter of intent, the earnest money deposit of the successful bidder to be forfeited. The said clause being relevant is also reproduced hereunder. Clause 12 stipulates the submission of documents with technical bids. Clause 15 pertaining to the stipulates the condition pertaining to say clause 15 being relevant is reproduced hereunder. Perusal of the above quoted clause would show that no subclause 1, Roman 1, categorically stipulates that the evaluation of the bid to be carried out in two parts, that is technical bid and price bid. And the price bid will be open and evaluated only on those bidders who are qualified in the technical bid only. But then also in subclause Roman 3, it is mentioned that in no case the contract shall be awarded to a bidder whose bid capacity is less than the estimated cost of the project to the tender. This aspect is relevant, taking into account the dispute involved in the present proceeding. Relates to abnormally low bids, bracket ALB. And it further stipulates as to what steps should be taken by the APDCL authority, by the tender committee, as well. The bids, the price bids so submitted are fall within the ambit of abnormally low bids. clause 29 stipulates as to how a dispute is to be resolved. A further perusal of the said clause, which relates to dispute resolution, that disputes should be settled immediately between both the parties by serving notice. And if such settlement is not reached within a period of 30 days, recourse to arbitration in accordance with the provisions of the arbitration and conciliation. 6 is the agreed mechanism for dispute resolution. Before further proceeding, this court finds it necessary to deal with the big capacity which has been specifically mentioned, dealt with at clause 5, capital C of section 2. The said section the said clause, more particularly the clause subclause capital C being relevant, is reproduced here in the relevant portion of the said clause. is reproduced here in that was difficult. A perusal of the above clause, it's law. Clause, it should subclause, should. As to how the available bid capacity is to be computed, the formula which has been provided in the said clause refers to the letter A meet the maximum value of electrical works executed in 1 year during the last 5 years. That can update it up to the price level of the year as annexure 1 capital E. Rate of inflation may be taken as 10% per year, taking into account the completed as well as works in progress. The letter N denotes the number of years prescribed for completion of the work for which the bids are invited. The letter B denotes the value that is updated to the price level that is of the existing commitments and ongoing works to be completed within the period of the completion of the works for which the bids are invited. In that respect also, the intending bidder has to submit an affidavit as per format indicated in Annexure 1F, along with all relevant supporting documents mentioned therein. In the backdrop of the above, this court now finds it very good to take note of Annexure 1 which prescribes the format for assessing the bid capacity of the bidders to calculate the value of A. As mentioned in subclause capital C of clause 5 of section 2 of the bid document. The said annexure 1E, if being relevant, is reproduced herein under 402. Perusal of the above quoted annexure 1E and more particularly the portion wherein put under quoted annexure 1 show that the figures to be mentioned in column A shall be supported by relevant copies of the work orders of the LOA, as well as the corresponding completion certificates issued by the officer not below the rank of CEO of the DPM or the Superintendent Engineer of Electrical Utilities. In the backdrop of the above, this court finds it very pertinent to take note of that the petitioner submitted the bid in two parts and uploaded the same on 15/10/2025. Simultaneously, the petitioner submitted to the respondent number 4 the hard copies of the bid. The records reveal that the petitioner, while submitting the bid pertaining to the bid capacity, also submitted the annexure 1 capital E as per the said format. The annexure 1E so submitted, which is at page 87 and 88 of the petition being relevant by the petitioner, which is at page 87 and 88, which is relevant, is reproduced here in under annexure 1E. Wait. Sorry. When did he submit the bid?
10/2020. 15/10/2020.
Then how is this dated, signed on 13/1/2026?
Which this document which he had submitted, he had initially submitted the annexure as it is contained there. page number 8, he was not accompanied with the affidavit. So when we asked for a clarification, he only submitted a document along with the affidavit. That is where the affidavit is signed.
Oh, he submitted that document.
He submitted this document. And
That PD. It is relevant to take note of that the petitioner, along with submitting the bid, also submitted the annexure 1E. The annexure 1E, which has been enclosed at the page 87 and 88 of the petition, is, however, dated, have been shown to be notarized on 13/1/2026. This court, during the course of the hearing, inquired with the learned counsels appearing on behalf of the parties as to how the said document would be dated post the submission of the petitioner bid on 15/10/2025. It was submitted before this court that the annexure 1E was submitted. Annexure 1E date was submitted, which was dated 4/10/2025, without any affidavit. The records were produced in that regard. And the annexure 1E, which was submitted by the petitioner, along with the bid being relevant, is reproduced hereunder. We keep these records for some time, huh? Annexure 1E. From a perusal of the said annexure 1E, it is seen that the petitioner herein laid emphasis on the total value of the electrical work done during the year 2021-22, which was of the value of rupees 107,87,83,000, and updating the same as per the formula provided. The value of the work was rupees 130,53,427,430. On the basis thereof, the petitioner applied the formula so provided in clause capital C of subclause capital C of clause 5 of section 2, and mentioned in clause annexure 1E, that the total bid capacity of the petitioner was rupees 26106.54 lakhs. It is, however, very pertinent to mention that not only in the clause 1E, annexure 1E, which have been quoted here in above, there is a mention that in order to prove the figures mentioned in clause A, or in column A, it has to be supported by relevant copies of the work order / LOA as well as the corresponding completion certificate issued by the officers not below the rank of CEO, oblique DGM, oblique superintending engineer of the electrical entity utilities. The petitioner also, while submitting the Annexure 1E, mentioned the said aspect in the said document. The record further reveals that the technical bid was examined and on 2/2/2026, out of 7 bids submitted, 3 bidders were found to be technically competent. This included the petitioner. Such status was uploaded on 2nd of February 2026. On the same date, 2 important developments took place. First, the price bid was opened. And secondly, a communication was issued to the petitioner. While opening the price bid, it was found that the petitioner was the lowest bidder, having quoted 9, 99, 31, 159.40. The L2 bidder quoted 10, 00, 03, 643. And the L3 bidder quoted rupees 10, 46, 00, 639.46. The important development was that a communication was issued to the petitioner on 2/2/2026. The said communication dealt with 2 issues. First, but related to the abnormally low bid of the petitioner. Thereby, the petitioner was asked to provide justification, which is required in terms with clause 28 of the notice of the bid document. And secondly, it was also mentioned. And secondly, the petitioner was asked to submit supporting documents with respect to Annexure 1 capital E for calculation of the value of the component A of the bid document duly signed by an officer not below the rank of DGM prior to issuance of the work order. A perusal of the said communication would therefore show that the petitioner had to submit these documents prior to issuance of the work order. Which have been interchangeably used as the letter of acceptance at clause 6 and 7 of the bid document, of section 2 of the bid document. The petitioner thereupon submitted a communication on 4/2/2026 justifying the price quoted by the petitioner and providing further details. The report further reveals that on 5/2/2026, a letter of intent was issued to the petitioner, informing the petitioner that the Chief General Manager, DNS APDCA, was intending to place an order for execution of the work at the rates quoted by the petitioner, subject to submission of additional performance guarantee as was required in terms with clause 8 of section 2 of the bid document. An acceptance from the petitioner was sought for within 7 days to the issuance of the letter of intent. The petitioner immediately on 6/2/2026 accepted the letter of intent and subsequent thereto, on 10 on 10/2/2026 provided the performance guarantee as well as the additional performance guarantee. You got it on 9. Gave it on 10.
Submitted on the 9th to us. We got a confirmation from the bank on the.
Submitted on 9/2/2026. Despite the issuance of the letter of intent by the APDCL authorities, by the Chief General Manager DNS of the APDC, and the acceptance of the letter of intent by the petitioner on 6/2/2026, and the submission of the performance guarantee along with the additional performance guarantee on 6/2/2026, comma. The Chief General Manager DNS sought for further in continuation to the communication dated 2/2/2026, informed the petitioner that the petitioner was yet to submit those documents in support of the annexure 1 capital E for calculation of the value of the component A of the bid capacity, duly signed by an officer not below the rank of a DGM prior to issuance of the work order. The petitioner was asked to submit these documents. On or before 1700 hours of 10/2/2026 so that the work order could be issued. It was also mentioned that in the event of non-submission of the requisite documents within the stipulated time, the letter of intent was liable to be revoked without further communication. The petitioner on 10/2/2026 submitted various communication, wherein various documents were submitted. Pertaining to work orders dated 21/2025, 13/3/2024, and the completion certificates in respect to those work orders. In addition to that, the petitioner, this document was submitted on 10/2. In addition to that, the petitioner submitted for the first time. In addition to that, the petitioner submitted the work order, which was the basis of Annexure 1E That is the work order relating to the year 2000, financial year 2021-22 of the value of rupees 129,6681,717. As well as the completion certificate dated 1/12/2022. The reports further reveal where that minutes
It's at page number, they start at page number 911.
there was another some other documents? No.
What if, for
No, no, no. Any other letters, correspondence? No. After 10 to? No.
after 10 to 19 or 19th, we wrote to them to return the bill. 19th of March, we had written to them to take back the bank.
No,
guarantee.
no. Prior to the minutes? No.
Prior to the minutes.
It further transpires that basing upon the submissions so made, the reply submitted on 10/2/2026,
Unless there was one communication on 19 to page number 320.
the petitioner, the Chief General Manager, DNS, APDCL, sought for clarification from the petitioner. Sought for certain clarifications from the petitioner. As regards the Annexure 1E submitted by the petitioner on 13/1/2026, and the additional and the said affidavit explicitly declared the maximum updated value to be 130.53 for the financial year 2021-22. However, the supporting documents, the works are found to be executed by an order dated 25/2/2026 to examine the clarification submitted by the petitioner in respect to the tender evaluated for the work in question. '26, the committee came to a finding that the petitioner failed to meet the prescribed bid capacity criteria, and therefore the petitioner, may be treated as non-responsive. Pursuant thereto, a speaking order was passed on 9/3/2026, whereby the petitioner's bid was rejected on the ground that the petitioner failed to meet the bid capacity criteria, and it was decided that the said work would be retendered. Pursuant thereto, a retender is here? No, yes. Huh?
Notice is page number 91.
Pursuant thereto, tenders have been issued in respect to the said work, which is the subject matter of which is also being challenged in the instant proceeding. The record reveals that the petitioner being aggrieved by the rejection by the minutes of the meeting dated 5/3/2026, as well as the speaking order dated 9/3/2026, and coupled with as well as the consequential action for initiation of fresh tender, have filed the present petition on 16/3/2026. It is also seen from the records that this court had, by an order dated 27/3/2026, this court further finds it relevant to take note of that when the writ petition was listed on 18/3/2026, the counsel appearing on behalf of the petitioner sought for time, and accordingly, the writ petition was listed on 27/3/2000, directed to be listed on 27/3/2026. On 27/3/2026, the learned coordinate bench of this court issued notice making it returnable on 6/5/2026. The learned coordinate bench, however, declined to pass any interim directions, staying the bidding process initiated by the tender notice dated 11/3/2026. The records further reveal that the petitioner thereupon challenged the order dated 27/3/2026 before the learned division bench of this court by filing a writ appeal which was registered and numbered as, give it the number, the said appeal was withdrawn or dismissed. It was disposed, the said writ appeal was disposed of by an order dated so and so, without interfering with the order dated 27/3/2026.
Petitioner was granted liberty to file an IA for
And liberty was granted to the petitioner to file an interlocutory application for early hearing. First, the records further reveal that in the meantime, the petitioner had filed the said interlocutory application, and this court, while taking up the said interlocutory application, further taking into account the issue involved, passed an interim direction that no action be taken on the fresh tender till 5/5/2026. On 5/5/2026, it is further seen that in the meantime, the respondent have filed their affidavit in opposition thereby supporting the decision taken in the minutes of the meeting dated 5/3/2026, as well as the speaking order dated 5/9/2026. Reply thereagainst has also been filed by the petitioner. Let me come back in 5 minutes. This court have heard the learned counsel appearing on behalf of the parties that they submissions made on behalf of the parties. Mr. K.K. Mohanto, the learned senior counsel, appearing on behalf of the petitioners, submitted that upon issuance of the letter of intent, which was in fact a letter of acceptance, the respondent's authority would not have cancelled the entire tender process, inasmuch as that same would amount to termination of the contract. The learned senior counsel submitted, drawing reference to clause 7 of section 2 of the note of the big document, and submitted that the performance guarantee is required to be paid, is required to be submitted only upon issuance of the letter of acceptance. The learned senior counsel further submitted that in terms of the letter of intent, the petitioner was required to submit a further additional performance security. To the extent of 5% of the contract value. The said letter of intent having been accepted by the petitioner, and thereupon the performance security as well as the additional performance security having already been submitted by the to the respondents. A contract had already come into existence. The execution of the agreement, which is mandated as per clause 6, is a formality which could have been, is a formality which is only to be done pursuant to the issuance of the letter of acceptance. The learned counsel, appearing on behalf of the petitioner, therefore refer to the judgment of the Supreme Court in the case of Dresser Random SA versus Bindal Agro Chem Limited reported in 2006, 1 SEC 751. And specifically referred to paragraph number 32. Paragraph number 40 of the same judgment. The learned senior counsel further submitted that irrespective of even assuming for argument's sake, without admitting that the letter of intent that the letter of intent dated 5/2/2026 is not the letter of acceptance, then also the impugned actions on the part of the respondent authorities in holding the petitioner a technically non-responsive is based on materials which are not in existence. The learned senior counsel submitted that the petitioner was held to be technically responsive after the evaluation being carried out by the Tender Evaluation Committee on 2/2/2026. And thereupon, the financial bid was open of the petitioner. Pursuant to the opening of the financial bid, the petitioner's bid was found to be the lowest, and the letter of intent was issued. The question of going into the question of again looking into as to whether the petitioner had the bid capacity or not did not arise, could not have been considered again. The learned senior counsel further submitted that the respondents themselves have sought for certain clarifications, and those clarifications were provided. along with all such documents which would have shown that the petitioner had the bid capacity. And then also, it is further submitted by the learned senior counsel that instead of looking into those documents which have been submitted by the petitioner on 10/2/2026, and the clarifications were submitted on another clarification. Which was given pursuant to the letter dated 1981 on, and the clarification was provided on 21/2/2026. These clarifications were not looked into. Rather, a fresh issue has been raised that the petitioner was working as a subcontractor, which had no relation with the terms and conditions of the bid document. The learned senior counsel therefore submitted that this is the case wherein the petitioner's bid have been rejected as technically non-responsive, most arbitrarily, unreasonably, and also against public interest, for which interference is required from this court under Article 14 of the Constitution. In addition to that, the learned senior counsel submitted that a perusal of the stance so taken by the respondents in their affidavit in opposition shows that the work orders are required to be issued by the CEO/BGM/superintending engineer of electrical utilities. Which stand apparently is nothing but an afterthought to reject the bid of the petitioner. In that regard, the learned counsel referred to the judgment of the Supreme Court in the case of Reliance. Reliance Energy Limited and another versus Maharashtra State Road Development Corporation Limited and others reported in 2007 8 SCC 1, wherein the Supreme Court categorically mentioned at paragraph number 38 that if the terms and conditions of a bid are ambiguous and vague, rejection on such terms and conditions would be violative of Article 14 of the Constitution. Mr. K.P. Pathak, the learned Standing Counsel of the APDCL, on the other hand, submitted that the letter of intent that the petitioner herein was issued only a letter of intent and a very perusal of the letter of intent dated 5/2/2026 would clearly show the intention was to inform that the petitioner was being intended to be issued the work order. The learned counsel submitted that a further perusal of the said document would show that the petitioner was informed that the petitioner had to pay and had to further deposit an additional performance guarantee, performance security, on account of the petitioners being abnormally low bid, which is 19.972% below the contractual value of the tender document. The said document under no circumstances can be said to be a work order, thereby leading to a formation of a contract. In this regard, the learned counsel submitted that recently the Supreme Court, in the case of State of Himachal Pradesh and others versus MS Oasis Cybernetics Private Limited, reported in 2026 SCC 34A, had categorically observed as to what right flows from an issuance of a letter of intent. He referred to paragraph number 15 of the said judgment and submitted that the letter of intent in the instant case at best can be can be said to be a promise in embryo, capable of maturing into a contract only upon satisfaction of the stipulated preconditions or upon issuance of the letter of acceptance.
The reported judgment, the paragraph number 36.
Paragraph number
36.
36. There's gone so much.
Right. Okay.
And what are they from D1? What is this paragraph starts from? D1 to D1 to paragraph number 11 to 15. D1 starts from. Itu to 30. Itu to 30. The learned counsel, appearing on behalf of the learned standing counsel, further submitted that for the purpose of that a perusal of clause 15 of section 2 categorically stipulates that the contract can be awarded to a bidder whose bid capacity is not less than the estimated cost of the project put to the tender. Whose the Standing Council submitted that in view of clause 15 Roman 3 of section 2, there was a clear bar in awarding a contract to a bidder who did not have the bid capacity. Elaborating further, the Learned Standing Council submitted that the manner in which the bid capacity is to be ascertained have been categorically mentioned in clause 5 capital C of section 2, which the Learned Standing Council further submitted that the formula which have been stipulated in clause 5 capital C has to be read in conjunction with annexure 1E, capital E, and 1 capital F. Was further referring to annexure 1 capital E, the Learned Council submitted that it is clearly stipulated that there was a requirement of providing the work orders, oblique, the letter of acceptance, as well as the completion certificates issued by the by an officer not below the rank of CEO oblique DGM oblique superintending engineer of electrical utilities. Referring to the bids so submitted by the petitioner, the Learned Council submitted that though the petitioner had submitted the annexure 1 Romani, but the supporting documents were not furnished at the time of submission of the bid by the petitioner on 15/10/2025. The Learned Council, Standing Council, however, admitted that after opening of the price bid, the APDCL authorities had on various occasions requested the petitioner to submit those documents. And these documents which were submitted, more particularly the document is that wind power document.
170. 170.
But these documents which were submitted and have been enclosed at page 168, 169, and 170 of the petition were submitted on 10/2/2026. Which form the basis of the details furnished by the petitioner in Annexure 1 capital E. The Learned Counsel submitted, Standing Counsel submitted, that these documents could not have been taken into consideration as these were not being issued by the CEO oblique DGM oblique superintending engineer of the electrical utilities. And they were, in fact, and these works were, in fact, executed by the petitioner as subcontractor. Anything more? I've heard the learned counsels appearing on behalf of the determination and analysis. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From a perusal of the materials on record as well as the submissions so made by the learned counsel for the parties, 2 points for determination arises. Number one, whether the letter of intent dated 5/2/2026 can be said to be a work order oblique bracket letter of acceptance, thereby amounting to a contract entered into by and between the petitioners and the respondent APDCL authorities. Number two, whether the action on the part of the respondent authorities in coming to a conclusion in the minutes of the meeting dated 5/3/2026, as well as the speaking order dated 9/3/2026, calls for any interference under Article 2 to 6 of the Constitution. Number three, as to what relief the parties herein are entitled to. First point for determination. This court has in detail narrated the facts in the previous segments of the in the earlier segments of the present judgment. A perusal of section 2, which contains the various terms and conditions of the bid document, only mentioned at clause 11 about issuance of a letter of intent and the forfeiture of the EMD on non-acceptance of the letter of intent within the stipulated period mentioned in the letter of intent. On the other hand, a perusal of clause 6 as well as clause 7 would show that a successful bidder issue a detailed work order period of completion would be mentioned. Guarantee which is required to be submitted has to be for a period valid beyond valid for 68 beyond stipulated date of completion of the project as per the letter of acceptance. From the notice from section 2, nothing could be discerned that the letter of intent, issuance of a letter of intent would amount to entering into a contract in fact, the penalty which is being imposed for non-acceptance of a letter of intent upon the successful bidder is the forfeiture of the EMD, which would be 25 lakhs. Later, the section 2 of the bid document further shows that the letter of intent, that something more is required to be done pursuant to the issuance of the letter of intent. In view of the above, let this court now take note of the manner in which the parties dealt with the letter of intent, dealt with the issuance of the letter of intent and pursuant thereto. As already stated above, the letter of intent was issued on 5/2/2000, as already stated above. On 2/2/2026, out of the 7 bidders, 3 bidders were held to be technically responsive. And on the very day, the price bid was opened, wherein the petitioner was found to be, petition number 1 was found to be the lowest bidder. The communication issued on 2/2/2026 to the petitioner is of relevance. Very relevant. It stipulated 2 things. One, that the petitioner's price bid was abnormally low, and thereby calling for justification in terms with clause 28 of section 2 of the bid document. And secondly, the petitioner was duly informed that there was no supporting documents with respect to Annexure 1E for calculation of the value of the component A of the bid capacity duly signed by an officer not below the rank of DGM prior to the issuance of the work order. The petitioner provided the justification by the communication dated 4/2/2026 However, the other document which we sought for in support of Annexure 1E was not submitted by the petitioner prior to the issuance of the letter of intent. Thereupon, the letter of intent was issued on 5/2/2026, wherein it was specifically mentioned that the judicial authorities were intending to place an order for execution of the work at your quoted rates in the form of it is further seen from the perusal of the letter of intent that the petitioner was further informed that the petitioner had to pay an deposit of additional 5% of the contract value as additional performance guarantee. The petitioner was asked to accept the letter of intent within 7 days. The petitioner accepted the same on 6/2/2026. Now the question arises as to whether the said letter of intent can be said to be entering into a contract, formation of a contract between the petitioner, number one, as well as the respondent number, as well as with the respondent authorities. This court finds it very pertinent to take note of that though Mr. K.K. Mohanta, the learned senior counsel, have referred to the judgment of the Supreme Court in the case of Brasa Rand Sutra, but the judgment of the Supreme Court in the case of Oasis Cybernetics Private Limited have duly considered the said judgment and thereupon have observed what is the status of a letter of intent. Paragraph number 32 to 36 of the judgment in the case of Oasis Cybernetics Private Limited, P Limited, being relevant, is reproduced hereunder. From a perusal of the above quoted judgment, it will be seen that the letter of intent creates no vested right until it passes the threshold of final and unconditional acceptance. Applying the facts, applying the said principle to the present facts, it will be seen that pursuant to the communication dated 6/2/2026, pursuant to the acceptance of the petitioner on 6/2/2026, it will be seen that a conjoint reading of the communication dated 2/2/2026, the letter of intent dated 5/2, the communication issued by the petitioner on 4/2/2026, providing justification, semicolon. The letter of intent dated 5/2/2026, and subsequently, the communication issued by the petitioner, the respondents on 7/2/2026, wherein the petitioner was again sought for the supporting documents in respect to Annexure 1E clearly goes to show that there was no unconditional acceptance to the acceptance made by the petitioner to the letter of intent. Under such circumstances, it is therefore the opinion of this court that there was no, that the letter issuance of the letter of intent dated 5/2/2026 did not constitute a contract between the petitioner as well as the respondent authorities. Second point. The second point for determination arises on account of holding the petitioner bid technically non-responsive by the committee constituted by order dated 25/2/2026 in the minutes of the meeting dated 5/3/2026, as well as the speaking order dated 9/3/2026. In the previous segments of the instant judgment, this court had taken note of as to when the bid was required to be submitted. And how the bid was required to be submitted. When and how the bid was required to be submitted. The bids were required to be submitted by the bidders online in the www.assamtenders.com. And thereupon, a hard copy of the said bid was required to be submitted. In the bid, amongst others, there was a requirement of fulfilling the bid capacity, of showing that the bidder had the bid capacity. The manner in which the bid capacity was to be ascertained has been provided at clause 5 capital C of section 2. A perusal of the said quoted clause, the said clause had already been quoted here in above. A perusal of the said quoted clause reveals that the formula which have been mentioned for ascertaining the bid capacity is to be made ascertained on the basis of annexure 1E as well as annexure 1F. This court also have quoted annexure 1E as well as the 1E as provided in the bid document, as well as the annexure 1E which was provided by the petitioner, which was dated 4/10/2025. From a perusal of the said annexure 1E, it reveals, submitted by the petitioner, it reveals that the petitioner relied upon a contract pertaining to the financial year 2021-22, which was of the value of 107,87,83,000, and applying the factor of updation, the updated value of the said contract was 130,53,27,430. In support of this contract, it was the requirement that the petitioner had to submit the necessary documents, that is, the work order oblique the letter of acceptance, as well as the corresponding completion certificate issued by the officer not below the rank of CEO oblique DGM oblique superintending engineer of the electrical utilities. It is very pertinent to take note of that the petitioner, very pertinent to take note of that the document on the basis of which the petitioner during the course of the hearing, prior to the lunch recess, it was submitted before this court that the document pertaining to on the basis of which the petitioner claimed the bid capacity was submitted along with the bid submitted by the petitioner on 15/10/2025. The said aspect was refuted by the learned standing counsel appearing on behalf of the PDCL. Under such circumstances, this court therefore directed the PDCL to produce the records which was produced post-recess. A perusal of the documents which were submitted by the petitioner by the perusal of the reports, and more particularly the bid which was submitted, the hard copy of the bid which was submitted, showed that the document on the basis which the petitioner claimed its bid capacity in Annexure 1E was not submitted by the petitioner at the time of submission of the bid on 15/10/2025. It is the opinion of this court that taking into account clause 15(3), which particularly mandates that the contract cannot be awarded to a person to a bidder who did not have the bid capacity. The respondent authorities ought to have held the petitioner technically responsive for not submission of the said document in support of the bid capacity as claimed in Annexure 1E submitted by the petitioner. The problem arose in the instant proceedings on account of the actions on the part of the respondent authorities after opening of the bid of the petitioner, financial bid of the petitioner, and finding the same to be 19.94% lower than the estimated contract price. And thereupon asked the petitioner to submit these documents. In fact, it is the opinion of this court that the very action on the part of the respondent authorities to seek from the petitioner, these documents at a later point of time violates the equality clause amongst the bidders, taking into account that some bidders have been rejected, technically rejected. It is very pertinent to take note of that this court, while exercising the jurisdiction under Article 226 of the Constitution, not sit as an appellate authority, but peruses, but takes note of, but only looks into the decision-making process. The settled principles of law stipulate that if the decision-making process is vitiated by arbitrariness, unreasonableness, irrational, as well as suffers from malice in law and fact, this court, in exercise of the powers under Article of Judicial Review, can definitely interfere. In the instant case, it will be seen that awarding the contract to the petitioner, in spite of the petitioner having not proved with documents submitted at the time of submission of the bid, would amount to violation of Article 14 of the Constitution, not against for the petitioner, but for the other bidders, of which some of them had been held to be technically responsive, not responsive. It appears that at the end, good sense prevailed upon the APDCL authorities to reject the bid of the petitioner and proceed with a fresh tender. Taking into account the above, it is therefore the opinion of this court that the second point for determination has to be held that there is no arbitrariness or unreasonableness, that the impugned decision to reject, hold the petitioner technically non-responsive. The second is that the impugned decision to hold the petitioners technically non-responsive and to go for a fresh tender do not suffer from arbitrariness, unreasonableness, or is vitiated by any malice in law or malice in fact. Taking into account the above, the instant writ petition, this court does not find any merit in the instant writ petition for which the writ petition stands dismissed with cost quantified at rupees 1 lakh. The judgment has been passed in a separate sheet. The judgment has been dictated in a separate sheet in the court, in open court. First, taking into account that there was an interim order passed, this court vacates the interim order. The respondent authorities would be at liberty to proceed with the tender process in accordance with law.
Grateful. I'm grateful that considers given enough time and has also considered all the aspects. Let us see what happens. But then may I request Bernard to partake of this concern? They consider it.
That will be good ground for you, for the division bench to inquire, don't you think? You ask, you should say that, you should tell this court that give us 10 lakhs. That might be a good ground for you. Okay, no cost. I'm vacating the interim order by this because this will take almost 3 days to come out.
The number of the writ appeal is WA 109/2026. And the date of the order is 8/4/2020.
So there will be an interim order which will be uploaded. This one, the interim order vacated, this will take 3-4 days. Keeping the records and return the records after it is being done. So don't take it. This recording is required. Because that is there that
Not,
Or you can give a photocopy of this.
why not taking the record?
No, take the photocopy, give us a photocopy. That particular EI, because I'm not going to rely on this one. I'm relying on this one.
Of annexure one, A1.
One E. One E.
One.
Yes, what is this? RS Mishra. Oh, you are here. What is this?
I don't see relating to denial of that capital sectional subsidy.
Which one? Capital investment subsidy.
Actually, this material, it is can be put earlier. And it was also cited. And the material is reconsidered since they were meeting. But that's meeting also, they directly simply refer the meetings and rejected on the ground of the dealer who only wants to. But then you go to I know page number 25.
You have to submit it within 1 year. You submitted 1 day after.
Actually, date of commercial production is 29/3/2017. And I on 26/3/2018, 26 March 2018, on hard copy, physical. But as per the Department of Trade, they have insisted that you have to file electronically. The late applications have to file electronically online. So immediately on 29 March, I filed electronically. The department contention is that on the date of commercial completion of commercial production, date of filing of the electronically on 29 March 2018, it will 366 days. The company will stand. So that is not allowed. So because this is more than 1 year, but this is the condition requirement. But as per my condition is that since within limitation, within the period of 1 year, because the day of commercial production, 29 March 2017, excluded.
Huh?
Excluded the day of completion of the commercial production. That it to be excluded from counting the period of 1 year.
When did you go for commercial production?
29 March 2017.
Huh? 20?
9 March 2007.
And you submitted on 29/3/2018. Where's your receipt? Where's the acknowledgement you submitted?
It's page number 50, annexes B.
There's no signature?
No, it's in here. It starts from the acknowledgement by the DIC Kamru on 26 March.
Where's the day? Who has signed it?
This director.
Where? Where's the signature at page 50? This in fact goes against you only. You're on one hand, you are saying that you are submitted on 28/3. This document shows that it was received on 26/3.
Yeah.
How is it possible?
26/3/2018. I had copied to the director.
Where's the signature?
This man,
Where?
it's page number 51.
Where? Where's the signature?
And based on this, the authorized security director side, and this the DIC Kamru 629.
Where is the signature? Then this is not a
And
receipt.
thereafter, I need to make it.
Where is that?
It's page number 52.
Where is the time period mentioned now? When you file an electronically, it will give a date time.
Page number 56 starts. The click for legal central investment 56 page 56 and actually E.
Huh?
Page 56.
Where?
In the bottom, it is mentioned the time, the date, 29 March 2018, 12 hours 25 minutes.
No. This is a printout.
Yes,
You took a printout, but where is the receipt?
so that is the problem. I not accused when I filed electronically. The problem, acknowledgement was not generated. Yes, sir. Acknowledgement was not generated, but time is there.
Do you wonder? Today also, without submitting, just have it out there, type it out there, make it ready out there and take a printout.
The department is not waiting on any objection on that. Department says that you have filed on 29, they accepting. You have filed on 29 March 18. But this is one day after.
So why you are saying that you have submitted on 28/3?
That is- I-
At least your affidavit in reply. At least it. You submitted on 29/3. As well. Online submitted on 29/3. Now, the department acknowledges 29/3. And your production date is? Commercial
29.
production is?
2017.
Huh?
17. 29 March 2017.
Where is the year of commercial production?
Yes, that's also there.
Where is the document? Hmm? Where?
Final page number 67. Page number 67.
67.
7.
No, not the, so where's the top, you have, the central excise thing, na?
No, it's not technically. It's not central capital investment subsidy.
Understood. When you are asking for the subsidies under this NEIIP.
Yes.
So therefore, you are also asking for central excise exemption or these things you are asking. Now, where is that? Where's the document? There will be a category mention the date on which you are entitled to.
Yes, that is also mentioned by the.
Anyway, they are saying 29 year. Now, let us see the term
Terms of
you
the
have to file within.
one
Where is that?
is for the
Where? Within 1 year. Some laws
7.
of
Is 39 plus 7. The claim
39. Claims for subsidy under the CCI so and so has to be submitted in the to the concerned DIC in the prescribed application form within 1 year from the date of commencement of commercial production. So within 1 year means what?
within well, I comment the start to complete my
Not by 1 year. What do you mean by within 1 year?
within well. That is
Within 1 year means within 365 days from the date of commercial production. So you say that one day has to be removed.
excluded. That 29 March which will be excluded.
Show me judgment where
It- That is as per the section 9 of the Building Code.
what do they say?
They said in case of the time computation, the first day should be.
What? No, no, here we are to issue that is a different thing, but here, how do you say so? On within? Within the, what do you mean the within?
Within
Within
One
1 year means what? Would it be 365 days?
we start from 30th of March 2001.
What will be the 1 year? No, if it is 1 year, I say, from today, within year, 1 year will be, today is 565. Just to be filed by 5/5
That's
next year.
next year by if that will be one counted, that is
No, therefore it has to be filed within 1 year.
one.
It will be 5/5.
So 29, the date of commercial production, so 29th of March is the 1 year.
No. It will be 28.
Actually, this first day to be excluded.
Why should we exclude that? Because it is within 1 year from today. When you say that, okay, let us see whether you use the word within the field. Yes, others may go, others may go. Where?
Section 9.
In any central act or regulation made after the commencement of this act, it shall be sufficient for the purpose of executing the crime in the 3 days or for any period to use the term from and for the purpose including the last and the series of the days of so and so. But here there is no from. It is within.
Using what?
Here we are to within. How will line come in?
That be 28 even.
Within has to be normally within your. We say that you file your reputation or file your affidavit within so and so. Would it mean the date on which you are to file?
Yes, ma'am. Limit is there, my lord.
What will be meaning of within? Let's see the dictionary. No, dictionary upon the house. What do you mean by within? Very difficult. Mr. Sahu always comes up with different things. You are put into difficult. And madam, you are the person who is going to pay. Not me.
The Supreme Court interpretation reported to 1972 AIRFC. Here also they have interpreted certain of the documents and other items. That has been come to the conclusion that they must be to interest. Paragraph 4.
You don't see it up. Funds. Funds are to within like things. Inside or not further than an area or period of time. 2/3 of the Californians live within 15 miles of the coast. In 1992, cross-border controls between the union were dismantled. It is duty or force. This cannot be done because the words
2022 compared to their meaning as the word within to be on or before. On or before. So you have to file your application within 1 year of the date of commercial production. It means on or before 29/3/2000 on or before. So then you will come in. Production is 29/3. So therefore, each application has to be on or before. It will go by these, not beyond. And therefore, it was held that the act would mean that on or before the expiration of the user period, the husband is bound to make and pay a period maintenance to the wife. And if falls fails to do so, then wife is entitled to recover it by filing an application before the magistrate of the council. But nowhere the parliament has provided that reasonable and fair provision in constitution. It is AI 2001 740. Let us see that 2001 740. What was 2001 740? Where is this word? You can confirm. There's no reason why the enforcer do the construction. Within 1 year from the day of motion. So on or before 1 year. Within 1 or before 1 year, it will calculate. 2001 740. So if it is on or before 27/9, 29/3. I tell you will have a pay. That's the issue. The taxes. What do you want to say? Both of you. Yes, return, don't tell me. Which court did you hear? The parrot, it is commercial product rules from 29 to 2017. If that is calculated within 1 year, we might have within 28. If it is considered within 1 year. Within will mean on or before. Within 1 year means by the on or in 60 days by the 10 by the if he files on 29 by the then it will be 366 days. Just use the word the application has to be filed on or before 1 year. On 1 year. What will be the 1 year? 1 year means 365 days. If it is to be considered 1 year, the first day has to be removed. That is why he's saying. And then 29/3 will be 365 days. If my first day is excluded. Let us see that carefully. But then this judgment should. Yeah. Which page you are referring to?
Paragraph four.
Hello?
Paragraph four,
Court.
that is a elaborate discussion.
When can the period of 3 months from the date of detention say can expire? In a period of 3 months from a given period. of the given detention, is to be excluded from the occupation, and the day on which such action is taken is to be included. Within one calendar month after the cause of such complaint shall arise. A. L. L. Principle that the day on which the cause for complaint arose have to be excluded. So this is what he is saying. Therefore, the word on or before means you have to file on means that day has to be removed. Yes. Or before. Before means the last date. So that day has to be 29. And if it is 29, he has filed it on 29 line. It is first day 29 has to be removed, then will be 1 year will be 29. 29. 1 year will be 29 or 28. Yes, another day will be 29. 29 that. Let. Let me go. Io. Dunque, che pezzi ci un nell'anino. Ah? What is this? I'm going to be. Ako po ba di yak geçeceğim ben?
Today, the expression within should be read as during or for, and this cannot be done because words cannot be construed contrary to their meaning, as the word within would mean on or before, not beyond, and therefore it was held that an act would mean that on or before the expiration of the iddat period, the husband is bound to make and pay the maintenance to the wife, and if he fails to do so, then the wife is entitled to recover it by filing an application before the magistrate as provided in so and so, but nowhere has the parliament provided that reasonable and fair provision and maintenance is limited only for the so and so. It's the word. Hello. That is it. Verdict part. List the matter again on Tuesday next. Right.